9:29. We start at 9:30. Please ensure, listen to me carefully, please ensure that your cell phones are off. We don't want them to disturb the proceedings. Make sure that they are either off or on silent. Thank you.
Good morning, Ms. Law. Good morning, Ms. van der Heever. Good morning, Mr. Matlala.
Good morning, Chairperson. Good morning, Commissioner.
Please pull the mics closer to you and switch both of them on.
Morning, Chair, and morning, Commissioners.
I greeted you and your mic was off. Good morning.
Good morning once again, Commissioner.
Thank you.
Thank you, Chair. Chair, Commissioners, you'll recall that Mr. Matlala had been subpoenaed to appear on the 7th of July, 2026. And on that date, Mr. Matlala's legal representative and I presented ourselves before you, and we had an engagement, the outcome of which was that Mr. Matlala's appearance was postponed to the 15th of July. Today, and the commissioners issued a ruling in that regard and on some other aspects. Mr. Matlala is present. We are back before you, and Mr. Matlala's legal representatives would like to address you, Chair. The issue about which she is about to address you is contained in the folders that have been made available to you, but I will leave it to her to take the commissioners through the contents of that folder. Thank you.
Ms. van der Heever.
Good morning again, Chairperson, Commissioners. We have prepared for your benefit and in support of our application for a postponement an affidavit that was duly deposed to by our client. Due to time constraints, however, we were only able to last night email an unsigned copy to my learned friend. The situation was that for a variety of reasons this could not be done earlier. I would like to very briefly, if it's necessary, Chairperson, Commissioners, just take you through our reasoning as to why we respectfully submit that a postponement in this matter should be granted.
Is there a signed affidavit now?
There's indeed a signed. It was commissioned this morning, and we thank the commissions, my learned friend and her team, for assisting us with that. Even at, I think, at 10 o'clock, there was another endeavor made to get it signed at the prison. There were some arrangements, but it just came to no fruition.
I do see it in a small folder in front of me. I read from my laptop, and that was an unsigned version. Thank you, thank you.
Chairperson, in short, we set out the history of what's transpired vis-a-vis Mr. Matlala, when he was arrested, how the events surrounding him has unfolded. And the most important aspect thereof is the fact that he's due to commence with a trial on Monday. We believe that he's got the constitutional right to attend this trial and be regarded as innocent until proven guilty, together with the other constitutional rights that we've dealt with in this particular affidavit. We respectfully submit that for him to deal with some of the issues, which issues play a very big part in the up-and-coming trial that starts in 4 days, would violate his constitutional right to actually challenge the evidence. We've indicated to you, for instance, that both Witness C and Lieutenant General Nkomazi relied on a statement that was given to them by Mr. Matlala.
Before you get to that point, let me ask a general question. Is the submission that a person required to appear before a commission, but who also happens to be facing criminal charges, can never ever testify before a commission prior to the finalization of the criminal proceedings?
May it please, my respectful submission is, if I read, I've quoted for you from Justice Jafta's decision in the Zuma matter, and it's quite...
That was a minority judgment.
Yes, but still, I would respectfully submit, with the greatest of respect, Chairperson, that where you have constitutional rights, that those constitutional rights, especially in the very unique situation that my
You see, I'm raising the point that that was a minority judgment to understand on what basis you can then rely on that dictum or on that legal statement to suggest, in response to my general question, to suggest that a person who is facing criminal charges can never ever testify before a commission of inquiry.
I respectfully submit that when you have a person that's either an accused or a suspect, I respectfully submit that your constitutional rights, with the greatest of respect, override the compulsion that there would be from the commission side for him to give evidence. He would literally forego a large number of his rights if he is compelled to give evidence under those circumstances. I think what we've done, if you would just permit me, please, Chairperson, I think...
No, I just moved my shoulder.
Yeah.
I did not say anything.
No, I think respectfully, what I've endeavored to show to you...
You know what we always say in the legal profession, both amongst legal practitioners and people presiding, that when counsel says respectfully, they actually mean the opposite.
I was told that many years ago by a good friend that presided over a trial where he said, that was the impression. But I
sorry for interrupting you. I'm sorry. Yes, please.
I fully understand.
Yes.
The point is that is the nearest that we could come to any authority on this point. And this issue to us was so important that we were going to try and see if we could actually deal with this matter, if necessary, elsewhere. Where we are right now, I respectfully submit, we don't have to go there.
Where is elsewhere? Is it a court application?
Yes. No, only the approach would have been to actually make, if the matter were to continue, to make the necessary full-blown legal argument and submissions to you, and then depending on your findings to take it on review. I'm honest, I've indicated that to my learned friend before too. It's because we so strongly believe that your constitutional rights, where the Constitution is the most important document in this country, those rights cannot be taken away from you by a commission who's got a certain mandate and who's, to quote my learned friend, on a fact-finding exercise. And more so, I think what we've done, Chairperson, we tried to set out to you why we believe that the constitutional rights, especially in this case, overrides what, and we're not fighting with what our client is duty-bound to come and do at the commission. What we say is, so far you've heard one side of the coin. This side of the coin that you heard, and you see, don't want to go into the details. As we said, we don't want to give away our litigation privilege in that regard. If we run our trial, we will show to you that what you've heard potentially is either not the truth or unlawfully obtained, etc. And for that reason, we will, at the end, of course, also assist the Commission in finding the truth in this, what I respectfully say is a quagmire of facts that you have to deal with. That is the one issue.
Or may I, before you go to the next issue, a difficulty that I have and that of course is subject to your response, is that this is raised, or this is being raised in a blanket fashion. Is the suggestion that any and everything that Mr. Matlala could ever say before this commission would be something that would be subject to the exercise of his Section 35 right? Is that what's being suggested? And that there is nothing whatsoever that he could ever say which would be unaffected by his Section 35 right? Is that what's being suggested?
That is not what I'm saying, and I think I've made that quite clear when I discussed with my learned friend. The difficulties that we find ourselves in at this point in time, and that was also the issue that prevented us from actually dealing with any affidavit beforehand, is that our client, and I was not party to that particular agreement, I only came in later, through a different legal representative with IDAC, the gentleman that's been named here was part of that, entered into to a 105A plea agreement. The magistrate then came back and found that the sentence wasn't just, and therefore gave all the parties time to go and reconsider. The issue that, that's when I got briefed to come back in, because there were very material and important issues that were not raised in the 105A that we believe would have materially influenced potentially the outcome of such an agreement. The only time that that matter could be dealt with, or the issues that was raised at that point, and if you bear with me, I have to choose my words carefully at this point because it's a very difficult situation, was when the magistrate finally made a ruling. So past Monday, that is a day ago, 2 days ago, he actually, in terms, I think it's a 105 capital A 9B Roman 2, if I'm correct. He actually said, well, he asked the state, what is your contention? The state said, oh, we wish to continue. He asked us and we said, no, we assail from the agreement. What then happens in terms of the Criminal Procedure Act is that it's as if there was never any plea negotiations happened. The issue for me is, and this is where I want to answer your question, Chairperson, is we were not involved in those negotiations. We know what transpired and under what circumstances in those negotiations. It doesn't take somebody to be a genius to having regard to what one's now learned, for instance, on Friday, what happened there. And my attorney and myself made the decision that we are not prepared to deal with any of these questions until such time as we are provided with the notes as to what transpired during these negotiations, as well as potentially any other documents that were drafted and signed. Because from the say-so that we've heard, it impacts on a lot of the questions we were asked to answer. And we are not prepared to just on somebody say, okay, we now exercise our Section 35 right on this and this and this. We want to come here as officers of the court, properly advising our client how that these are questions that you have to answer. You're compelled to answer them. You can't, let's say, invoke Section 35 rights. And as we sit here, Chairperson, we still can't give you an answer to that question because we still don't have that. So there is, of course, and that is the long and the short of it, there is answers that you can answer. But at this point, I can't come to you as an officer of the court in honesty and say to you, okay, this is my instructions. I need to, because of this quagmire of IDAC's involvement, be sure that what we say to you is truthful, because there's also the penalty of perjury, and of course there's a previous inconsistent statement that can be raised at any stage. So for that reason alone, I agree with you. There are issues, of course, you can never assail your compulsion to answer to those. But until such time as we can present to this Honourable Commission an affidavit that we satisfied contains is based on facts and where we can invoke that right correctly, I cannot even go as far as to say we don't know this person. For instance, I could have come to you now because I know from the list, Annexure A, we could give you a list and say we don't know these people. But for the rest, it's not in your interest that we present, in your, and I mean the Commission, the Royal U, interest that we present in piecemeal fashion answers to questions. The fact of the matter is that my client has been made out to be this mastermind by everybody. And we respectfully, from our interaction, say that there's a fallacy in that. And we intend to show...
Please tell me when you are done with
Yeah.
responding to my question.
Yeah. So,
before you move on to another point.
I've basically responded to your question.
Thank you. Let me tell you how my difficulty arose. It's because the affidavit does not clearly delineate the issues either at all or as clearly as you have done now. And that is because, for example, the application says the entire commission process must be postponed pending finalization of the criminal process. So it's on that basis that I then ask you, does that mean there are no questions whatsoever that Mr. Matlala could deal with before this commission? Now you have responded and said, no, there are. So there are issues that he can deal with before this commission. Now my next question is, why can't that happen before the criminal process has been finalized?
Because I, as an officer of the court...
At this level,
I'm honest with you.
No, let me finish. At this point, focusing only on those, this of course is not a ruling on whether we agree on the Section 35 point. That's something we're still to apply our minds to. But focusing only on the issues that can be carved out of the Section 35 issues. Why can't those be heard or dealt with by this commission before finalization of the criminal process?
So there's three reasons. The first I've already dealt with. I said to you that there was negotiations ongoing and I need to understand in those negotiations who, what and where. And without that, I cannot,
Are you talking negotiations
with IDAC,
relating to the plea deal?
relating to the plea.
That's history now. I'm asking you about now. I'm
it's-
asking you about now, please.
It's not history because it's only if I have regard to those and those are handed over that I can come and say I can answer question A and B but not C and D, because it is clear from what we have been given that is a suspect on these issues. So you cannot answer that question. So that is my first point. I cannot at this point in confidence say to the Commission, and I won't permit my client to deal with those until such time as I know what they have negotiated with him, what they've asked him, what he's committed to, what he's not committed to.
Is that not an issue relating to whether there should or shouldn't there be a postponement? And that's not what I'm asking you about.
No, sir,
I'm asking you about the precedence.
Yes,
Which of the two processes must precede the other?
But-
So I understood you to be referring to the plea deal in the context of saying, prior to that being finalized, I do not know what to do. I must wait until the end.
No.
That's something else altogether.
No, that's not what...
It has nothing to do with whether. Once the plea deal is dead and buried, must the commission process wait for the criminal process? So the earlier issue, the plea deal, is finalization or even non-finalization has nothing to do with the question I'm putting to you.
It does indeed, Commissioner. If you will permit me just to explain to
All
you.
right.
During a plea deal, there is much more than the simple wording in the plea deal that takes place. There's other negotiations that happens between the investigators, the client and the attorney. And during those investigations, there's names that come up, there's information given, etc. And during that negotiations, a person potentially is, and I'm trying to keep it in the abstract, is told, you are a suspect on this matter. Let's say you're a suspect that you connived with General X to do A, B, and C. General X doesn't appear, for instance, in the plea deal. It's discussed there, there's questions made, there's recordings made, but General X appeared in the Regulation 10.6. Now, for me to deal with whether he's a suspect or not, in respect of anything to do with General X, I need to know what was discussed during the plea negotiations. And it's not just somebody sitting there and now we're drafting a 105A.
For what purpose? You are doing that for what purpose?
For purpose of invoking my right to silence on that. I can say,
No,
I've been
then
told...
you don't get me altogether. Then you don't get me altogether. We have already, please listen to me. We have already made common cause that there are issues in respect of which Mr. Matlala is able to deal with before this commission. Now, you are talking about issues that, post the plea deal, may also fall under the Section 35 dispensation that you are claiming. I have said, let's put aside all of that. So what you are telling me falls, according to you, under that basket. I have said, let's put that aside. And let's address our minds to those issues about which there is no question regarding them being heard by this commission. That is what my focus is on. And it's on that basis that I say to you, I do not understand your point about the plea deal and its relevance to my question. I hope you get me now.
Let me again try and explain to you, Commissioner, or Chairperson. I can only say to you, we've made common cause on the issue itself. But I can only tell you, as an officer of the court, which of those...
No, I will not give you time when you seem not to understand me. I am saying, I'm not interested in the nitty-gritty of what falls under the Section 35 bucket. I'm not interested in that nitty-gritty. I'm looking at the broader question of, on those issues on which there is no question whatsoever, which can be dealt with by this commission, and you've agreed that there are. On those questions, why can't those questions be heard before the criminal process has been finalized? Whether, even accepting, as you argue, that there are some issues coming out of the plea deal which fall under the Section 35 basket, even accepting that, you have said there are some which do not fall under that basket, and my focus is only on those aspects that do not fall under that basket. So clearly, what you've just said about the plea deal is irrelevant to my question.
With the greatest of respect, it's not irrelevant, Chairperson, because I cannot at this point in all, as an officer of the court, distinguish between what we can answer and what we can't answer. We can only say to you, the only things...
You will never understand me. Please go on to your next point.
No, I do understand you quite clearly. The only issues that my client can answer, Chairperson, at this point, that we say that we form common cause on is who he doesn't know on the list of the 10-6. The rest of the issues, if I may please finish, rest of the issues, I cannot say to you, I am prepared to answer this because I don't know if I can.
I have not asked you that. You are trying to answer a question which I have not asked you. I have not asked you that question. I have simply not asked you that question. I am asking you a general question. It has nothing to do with specifics, and that general question is, on those issues on which there is no question whatsoever, those issues, I will accept for a moment, for purposes of this debate, that there are plea deal issues that fall under the Section 35 basket, and which therefore will not apply to my general question. So I'm asking you this general question again, and it is this. On those issues which even you, whether today, tomorrow, or by the end of this year, there can never ever be a question about them falling under the Section 35 basket on those issues. And again, I repeat, this is a general question. On those issues, what would the basis of us not continuing with those prior to the finalization of the criminal process? What would the basis of not doing so be?
The only basis would be that the evidence will then be presented piecemeal. I've said to you, Chairperson, and I stand by it, the only things that he can say to you at this point, I don't know A, B, C, D, and E. The rest of the issues we cannot deal with. And I, with the greatest of respect, do not think it would be in your interest for him to sit here and say, I don't know this person, I don't know this person, I don't know this person. That's the only issues that we can form common cause on that he can at this point answer. We are trying to come to the Commission and answer what we can. The problem is, and I'm sorry to repeat myself, I can only do so if I know what he can answer is shown to me in black and white. I am trying to ensure that my client comes to this Commission and gives evidence to you that is to your benefit, i.e. the work of the Commission. And not for him to answer things that we as legal officers, and you've been in our position before, you can never allow a client to go on oath if you as the lawyer are not sure what he said there is right. I will not perform my duty as an officer of the court if I allow that. And for that reason, right now, I can claim privilege clearly on certain issues. I can say, this is my Section 35 issues. The others, I say to you, I can't at this stage because I don't know what's going on in the background. So it might even be once I've got the documents that I think is necessary for me to decide it, that we can move on that. But right now, we can't. And I respectfully submit that based on the remainder of the issues that we've put here, that this Commission should allow him the opportunity to finish the trial. And more so...
Again, please tell me when you are done
Yes,
responding to my question.
And then the last thing is, I think the thing that concerns me the most is, and we've taken the liberty of sharing a privileged document with you pertaining to the opinion. The one
I think that's something else. Then can I come in? Yeah.
And when that is, for me personally, is very concerning at this point in time.
When you referred to a piecemeal hearing, this is just for clarity. Does that mean you are going back on the earlier acceptance of what I posited to you, which was, is it something that can be done for this Commission to entertain proceedings that relate to issues that have nothing to do with Section 35? And I understood you to be saying yes. But now, towards the end of your submissions, you said, I don't know, I'm paraphrasing, I'm not sure of the exact words you used, but you said something like, it wouldn't be desirable to have a piecemeal hearing, something like that.
Yes.
Is that going back on what you said earlier, which was to agree with what I posited to you?
Yes. As I said, and the reason why I say piecemeal is all that will happen at the end of the day, Chairperson, is he will sit here and say, I confirm I don't know these people. And that is literally all we can do at this point. That is the only part of the Regulation 10.6 that we are at idem with each other. I say nothing prevents him from going under oath and say, I don't know person A, B, C, D, E, and F, and sit back. The rest of the issues, again, I want to emphasize, we want to cooperate. We've put it in our paper. But give us an opportunity to ensure that what we come to the Commission with is truthful. It's based on facts.
Another thing which arises from what you said in the context of the plea deal, and if I understood you correctly, you said this in the context of dealing with why a statement was not prepared. And again, if I understood you correctly, you made the point that you or your client had to wait until that plea deal process had been finalized so as to know whatever it is that related to the facts eventually. Here's a difficulty I have. Surely facts cannot change. Facts are facts. And I do not quite get it why Mr. Matlala could not have made his statement. He knows what the facts are, regardless of what the outcome of the plea deal were to be. He knew the facts, and therefore, from where I'm sitting, subject to your response, he could have said, these are the facts, and here are my responses to the notices that I have received.
But Chairperson, the situation is
Or just to finalize, the facts could not be this or that, depending on the outcome of the plea deal. The facts are facts.
no, it is different because when people enter into plea deals, there's certain consensus reached and it goes, it's dealt with in totally different way, 105As, than what would normally, as you say, admit certain facts. If you go on a 220 or 115A and you admit facts, it's a different story. A plea deal goes beyond it. So very often, there's facts behind it. As long as that 105A stood there and the magistrate has not ruled on it, our submission is that the issues there, he could not entertain his Section 35 rights on those. He could not come to the commission and say, listen, I'm a suspect or an accused on this particular matter, and therefore I invoke my right to silence. It's a live process, and that live process has many complex issues behind it. So for that reason alone, he could not depose to that, to any affidavit here. I understand what you're saying, Chairperson. I understand what you're saying. But if he were to honestly depose at that point before Monday to an affidavit, he had to answer questions that we believe, because of him assailing from the 105A, he now has the right to invoke a right of a constitutional right.
But the Commission's interest would be facts in accordance with what Mr. Matlala knows. And that has nothing to do with whatever it may be that informed what he said for purposes of concluding the plea deal. So on that basis, I do not follow your response.
I stand by my response, Chairperson. I cannot, again, as an officer of the court, make my client say I invoke my right here and there and wherever, when I know in law the situation is that is a life process and he cannot invoke that right at that point in time. The facts, with the greatest of respect, you say that you have to answer facts, but facts have context and facts have background. You might see something as a fact because you've got a General Mkonazi that comes and says, oh, he said A, B, and C. I come back and I can't exercise that constitutional right before you and say, whatever General Mkonazi said, he got out because the client was forced unlawfully and unconstitutionally to answer questions. He was not allowed, for instance, to have access to a lawyer. He was questioned for over 6 hours without food, etc. That surely influences that fact. Then it becomes no more a fact that we can rely on. It becomes a fact. And we know you are dealing with it as a fact because it's part of the process here. But it's a fact that was obtained unlawfully. And we have the right to make sure that you also know down the line that the facts that you rely on, General Mkonazi, for instance, say so, are not lawfully obtained facts. I can't come here and I'll say, please call so-and-so, put him in the box so I can challenge him as to how these facts that everybody now relies on were obtained. I can do that, however, because it's part and parcel of my trial that's starting on Monday.
It's exactly because there are those allegations, not only by General Mkonazi, but by many others, that the commission wants to hear from Mr. Matlala, get his and underline his facts. You emphasize facts coming from General Mkwanazi, and I add him and others. You emphasize those facts. What the commission is interested now is facts from Mr. Matlala. But anyway, unless you want to comment on that, Commissioner Baloyi wants to ask a question.
Chairperson, as I said, those facts are facts that General Mkwanazi rely on, that he says he obtained from my client. And we say what he relies on, you should not accept. And we can show you in due course why you shouldn't
We've not
accept. It's
accepted
just one
anything.
example.
We've not accepted anything at
No,
this
but
stage.
I'm saying to you,
Ms.
it's just one example.
Yeah.
If I can, unless you want to hear me.
Commissioner Baloyi has a question.
I just want to make sure that I understand what you're saying. I've understood you to say that you want access to the negotiations and the documents and everything that went on in the lead up to what would have been a plea deal that is approved by the court. And you say because you haven't had access to that, you're unable to get Mr. Matlala to respond to the notice that he has been given. Did I understand you correctly?
Indeed, because in that process that leads up, I'm sure, Commissioner, you've gone through those processes yourself. There's always deals that are made.
Your microphone is off.
Sorry, there's deals that's made. And that process to come to a finalization of a 105A involves a quid pro quo. And I need to see what the quid pro quo was.
But what does it have to do with the statement that must be submitted to the commission?
Because let's say...
Let me finish my point. That process has concluded, even if what you refer to or what you describe as the quid pro quo were to be relevant to the answers in the statement to be submitted to the commission, which I'm not saying they are, even if they were to be relevant, that process has concluded, has been declared in accordance with the law to be null and void. So for all intents and purposes, it never happened. That's what that concept means. Why is that a hurdle to Mr. Matlala submitting his statement, answering specific questions that have been put to him, and you know that in answering those questions, he's entitled to say, I don't know anything about this, if he doesn't know anything about it. And the assumption that we must make is he's going to be truthful in his responses. And if he doesn't know that's what it is, why are the notes and the documents that comprise or that constitute what you say is a quid pro quo, why are they relevant for our purposes?
It's highly relevant because let's speculate. I don't want to go into detail, but let's speculate for a second. In order for them to offer this deal, they sit around a table and they say to my client, we want information on A, B, C, and D. And A, B, C, and D forms part, let's say, of your list. But A, B, C, D is not part of the plea agreement. That is the deal that we cut here. You give us this information as an example, and we will continue. We will enter into this deal with you. So, for instance, if there is, let's say, a Section 205, Section 204 affidavit opposed to, I want to see that because I want to see in that what transpired. Or what was admitted in that statement, number one. But number two, I want to see, and I feel very strongly about it, what transpired during these plea negotiations. Because in law, normally what happens, it's recorded. Because I have been quite vocal about the fact that, no, I'm trying to choose my words very carefully. The process that was followed, I've made it plain to you, I was not going to be involved in it because I didn't trust it. That's the 105A process. And subsequently, I'm even more concerned about the process that was followed.
I understand.
And what I'm saying to you then is, in that negotiations, names could have been mentioned, admissions could have been made, evidence or Yeah, he could have disclosed evidence to them. And I
that's-
can't deal with it if I don't see what
But
happened
that's
there.
information that's within Mr. Matlala's knowledge. I don't understand. I don't quarrel with you wanting to know for your purposes. For your purposes. I don't take issue with that. So you don't need to persuade me that you want to know, you're concerned about how that process was conducted. That's not the issue. The issue that I'm raising with you is specific questions were asked of Mr. Matlala to speak to in his statement. And those issues are the issues that have been identified as relevant to our terms of reference and for our purposes. What I do not understand from you is what is the problem or what is the hurdle to Mr. Matlala answering those questions if you do not know what happened in the negotiations? Because where I'm sitting, that negotiating process has nothing to do with us. It's completely irrelevant for purposes of the commission and getting the answers that we require from Mr. Matlala. Of course, we know that Mr. Matlala has the privilege to claim self-incrimination. I will not answer this question because it will incriminate me. I have a trial coming up. We have experience in this commission about that. People have appeared and raised that, right? And we abide the law when it comes to those issues. What I don't understand in the long engagement with the chairperson that you've had is why it is that until you have received the notes and have an understanding of what happened in the quid pro quo, or what it is that was given in a process that, by the way, is null and void as matters stand, we could never, as a commission, you know that, we could never make any reference whatsoever to what happened in that process, even if we had insight into it. We don't have insight into it. We don't know what was discussed. We don't know what documents were shared, what information was shared. But even if we knew that, we could never reference that because that is an entirely separate process from our process, but that process is now null and void. So nothing that is said in that process comes before us by virtue of having been said in that process. If you accept that to be the correct position and the position of law, not just our conduct, but to be the correct position of law, you haven't said or explained why Mr. Matlala cannot submit his statement, answer the questions in whichever way he chooses, answer the questions asked of him until you've had insight into what happened between him and IDEC. The simple proposition being, he's been asked questions that are presumably within his personal knowledge, and he can give you instructions about those. And where he has no personal knowledge, he can say, I know nothing, and he'll come and tell us that. I don't understand the basis on which you are resisting. In fact, you say, I can never advise my client to answer questions. Well, it's for your client to make the decision whether to answer. Clients work on counsel's advice. It's not you who's answering questions. It's him who will tell you, this is what this question means. And you will say to him, well, that incriminates you. My advice is you don't give them that answer because it incriminates you. It's ultimately up to him to make the decision, not for counsel to say you don't answer because it incriminates. So far, you haven't said to us, Mr. Matlala refuses to answer the questions that you have given to him. You haven't said that. Your case throughout is, I need to see what was discussed with IDEC, which I say, and I say it firmly, it's completely irrelevant for purposes of your postponement and for our purposes. You keep on saying that, but in fact, what you should be saying to us is Mr. Matlala refuses to submit a statement to the commission because of A, B, C, D. Then we deal with it on that basis. Thank you.
Commissioner, there's a few issues. The one thing that I've noted in the 10.6 that you, I assume, take quite seriously, there's a specific question that says, has any person tried to influence you, intimidate you, etc.? Now, you cannot say to me that that is not relevant to the Commission's work.
The answer can only be yes or no. And the rest would be the detail. If we are interested in a yes, if he says, yes, someone has tried to intimidate me, the commission may well follow up when he presents evidence and say, well, give us the detail of that intimidation. But the answer is yes or no. There's nothing, there's no privilege about it. There's absolutely, and it's a matter that is within his personal knowledge. It doesn't depend on you seeing the documents from IDEC. It's an answer that Mr. Matlala is in a position to give to you. So it's a bad example that you're choosing.
No, I respectfully disagree with you, because if there are, if for instance there's intimidation, or for instance if there's undue influence, with the greatest respect, I've come across, and I've got no problem that you yourself have come across people that do not understand that what they are subjected to is undue influence to get to a point. So I stand by my answer previously. The other issue that I want to raise with you is, as a litigator, we've got ethical obligations when we deal with clients to ensure, and you're right, I advise my client, that is my duty. But I do not know of a single attorney or an advocate in this country that will allow their client to depose to an affidavit if they're not satisfied that what is in that affidavit is correct. We all do this. We do litigation, we run trials. That is our ethical obligation. And if the issue is then that I am obstructing the process, if I want to put obstructed in inverted commas, by insisting on making sure that what I have is correct, then blame me. Don't blame my client, because I believe that in acting as I am, I'm carrying out my ethical obligations. I've been doing this for long enough, so have you, to know things are not black and white. There's a vast grey area in between. And I want my client to come and assist the commission, but I want him at the end of the day to do so free of anybody coming and saying, you're committing perjury because we've got something to the contrary. I want him to come here without later on falling foul of a previous inconsistent statement. It's my job to make sure that that doesn't happen.
Can I ask you this question just to make sure that I understand your position? Is your position, and Mr. Matlala, when I say your, I really mean Mr. Matlala because he's the client, is your position that until you receive the material from IDEC that you say you need to see, what was given, what was offered, until you receive that, this commission will never receive a statement from Mr. Matlala and he will never testify? Is that what you're saying?
No, that's not what I said.
Then what is the relevance of the IDEC background material in a process that has been declared null and void?
Maybe I must just go one step further and say that I have discussed with my learned friend, and I actually didn't want to go there, that we can sit down at some stage and try and work out some of these issues. But I'm saying to the Commission that all we want is we want an opportunity to comply with the 10.6. I've never said we're not going to comply with that. We want an opportunity to do so. The second issue is, and I want to almost draw...
Sorry, what is the opportunity? I think...
I want to postpone it.
I want to make sure that we understand what it is you are seeking from us commissioners. When you say, you are not saying that until you've received the IDEC material, Mr. Matlala can never submit a statement and he can never testify. You're saying that's not your position.
My position is not, it doesn't only relate to IDEC. Can we just go one step further?
Let's take it one step.
It doesn't only, but let me just go. Yeah, it's on.
Thank you.
It goes further. The Commission is in possession of recordings that was only disclosed to us. So
no, hold on. I want us to do one step at a time so that we tick off what is the issue. If we've resolved an issue, we both agree this is off the table now. Now we are going to a different topic. I know that in your affidavit you do speak to recordings and transcripts. We will still get there. You haven't engaged with that. I just want to be clear, because my understanding from the time when you were engaging with the chairperson, and hence my questions that I've asked of you, my understanding of your position was, and still continues to be, that until you have received from IDEC, whenever that will be, if they will ever give you that material, until that point that you've received that material, Mr. Matlala can never depose to a statement, because you would not let your client depose to an affidavit where in future he gets met with previous inconsistent statements and all of that. So I ask the question so that there's absolute clarity about what it is that we are dealing with. Is your position, let me repeat, is the position that you are adopting that until you have received the IDEC material that led to the now collapsed plea deal, Mr. Matlala will not be in a position to file a statement to the commission, and Mr. Matlala is not in a position to testify before the commission?
Chairperson, of course, that is my position at this point in time, because I'm ethically bound to act in that manner. Again, I say to you, I cannot think of any other council that would act differently than I do. So, but
Yes.
This is not an impediment, because I truly believe we can get the information relatively quickly. So I'm saying to you, please just take into account, this plea deal collapsed on Monday. It's Wednesday. So we've got this very short period. But that's not the only thing that I say.
No, don't go to the other things.
Well.
I'm more interested in the question of principle. I want to establish the principle. It's important to us. If by the time we finish here, you rise and your position is until he has received the IDEC material, or you have received the IDEC material, whenever that will be, maybe tomorrow, maybe day after tomorrow, maybe next year, maybe not ever. I want to establish the principle to make sure I understand the principal position. Is the principal position that until you have received and considered, as his counsel or his legal team, until you've received and considered the IDEC material, Mr. Matlala will not file a statement and he will not testify? Is that the position you are conveying to us?
Until such time, I am told by any person in the legal profession that I'm wrong in going to a point where I say, part of what I'm doing here is to protect my client's rights. I stand by that.
Yeah,
I
Miss-
say it is
No, I must insist, Ms. van der Heever, I've asked a direct question. Let's stop this going around. I'm not asking you about being advised by somebody, being told you're right or wrong. And I haven't yet expressed a view that you're wrong, by the way. I'm not saying your position is wrong, right? I'm still at the point where I want to understand the position. And it is a yes or no kind of question. You have motivated, you have argued, and you don't need to do that any further. I'm now at a point where I want to understand, is the position that until you have the IDEC material, Mr. Matlala will not file a statement and Mr. Matlala will not testify? The answer is a yes or no.
My instructions are that we will file a statement as soon as possible.
What is your answer to my question?
I've told you, Commissioner.
So you will file a statement even if you do not have the IDEC
That is
material?
my instructions at this
Okay,
point.
that you will file the
I got
statement.
instructions from my attorney to deal with it in
Thank
that
you,
regard.
thank you.
May I just, before Commissioner Kumalo asks a question, he says his point is now covered.
Okay.
You said earlier you had a discussion about timelines or the timing. I just want to find out at this stage, before you continue with the rest of your submissions, to find out by when the statement that you say can be filed, by when will that be filed?
Chairperson, I've not
I know perhaps
arranged
it's something,
yeah,
it's something you may want to engage Ms. Sillo about, but I would just like to hear from you.
May I take an instruction just for a
Yes, yes.
We think we can do it in 2 weeks. Of course, please take into account we're starting a trial on Monday. And that is, of course, also premised on the fact that we get the recordings that's been referred to and relied on by certain witnesses in the commission. And I've discussed another issue with my learned friend, but I'm not going to deal with this on the record. Me and her have managed so far to, between us, sort these issues out. So if it's convenient and if so permitted by the commission, my attorney says that we can probably do that in the next 2 weeks. Because, of course, maybe just for the record, we can also obtain some of the information through the erstwhile attorney. So.
On this and possibly any other issues that may require discussion between you and your colleague, Ms. van den Heever, we'll give you time, so we will adjourn before any ruling is made. But I don't think you were done with your submissions unless you tell us that you are. If not, you may continue.
I think my submissions are quite clear pertaining to the upcoming trial. I think we have the right to be presumed innocent. This commission is watched by many, many people, and I'm just afraid, as it goes, the questioning of him, and I'm not necessarily saying by yourselves, but I know my learned friend might give the perception that he's guilty, and he will go into his trial with baggage, and I'm trying to prevent that. I've set out for you, I think, quite clear the issues that we are dealing with. And then, of course, I'm asking you to pay serious consideration to what is contained in the opinion that we've urgently obtained for you, because I find it very persuading. I hope you do too. And we are endeavoring to deal with that issues the best we can. Thank you very much. Sorry, Chairperson, my attorney has just asked me to emphasize the point that part of the delay had to do with the recordings that was not given to us, and which is quite important.
I'll give you an opportunity. You just... Ms. van den Heever, we heard what you say, and what you said you wanted to emphasize, unless you want to add to that.
Just been asked by the attorney to emphasize the point. Those recordings are vital. They've been referred to by witnesses. They've been, and the day we received the recording, and I thank my learned friend for her intervention in that, was the very day that the statement was due. As you can imagine, we've got limited access to the client. I personally had to phone the head of CMAX to ask, please, can the attorney go in? And he's not even finished listening to the recording. So it's also impeded quite a bit of the issues. And then lastly, maybe I should also emphasize that you please take into account, Commissioners, that whilst this process of the 105 was unfolding, we were not part of it. We couldn't get instructions on it because somebody else was dealing with it. So even if we wanted to, we were basically, and I say this respectfully, cut off from dealing with the issue for other reasons that I assume will at some stage come to light here. Thank you very much.
Thank you, Ms. Van den Heever. Ms. Sello.
Thank you, Chair. Chair, I have a witness whose testimony was deferred to later in the morning, and I'm quite mindful of that witness. So that constrains me significantly as to how I respond. So I will try to be as brief as possible, and in so doing, perhaps to assist the commissioners. I would like to start with where my learned friend ended, which is an offer to file the statement in 2 weeks. That effectively takes care of the first part of the ruling, or was it the second part, but one part of the ruling of the 7th to file in 2 weeks. We have spent over an hour engaging, my learned friend engaging you on matters that don't get to that conclusion. That's where she ought to have started and would have saved significant amount of time. I say this because on reading the affidavit in support of the application for postponement, one must bear in mind that we appeared before you on the 7th of July. Everything that is in that affidavit predates our appearance. And it is at that appearance, notwithstanding the facts as asserted in that affidavit, an undertaking was made. So if those facts were not relevant prior to the 7th, and the very facts, notwithstanding the very facts, they were able to make specific undertakings, which included filing by the 8th of July and appearing on the 15th, I truly do not understand how then they become relevant come the 15th. They revive, they suddenly become relevant. The challenge with this application is nothing in the affidavit speaks to the period between the 7th and the 15th. Nothing happened that even threatened the undertaking made to you on the 7th, Chair. So the question is, why must I entertain this entire argument, if not to waste the Commission's time? Mr. Matlala's legal representatives were informed by certain facts to conclude that they're in a position to make certain undertakings on his behalf. They don't come here and say, those facts have changed. They don't come here and say, since the undertaking was made, new facts have come to light that make it impossible for us to comply. So technically, that undertaking made is not worth the paper it's written on. And this is a complete waste of the Commission's time.
Can you,
Now,
sorry,
yes.
Mr. Lo. Can you please make me understand something Ms. Van den Heever said on the 7th?
Yes, Chair.
Ms. Van den Heever indicated that she was agreeing to the filing
Yes.
by the deadline that was indicated, something like subject to the reservation of Mr. Matlala's rights. Even as she said that, I wasn't sure in my mind what exactly that meant. What was your understanding?
My understanding...
Of course, maybe I should have asked, I should have put that question to Ms. Van den Heever.
It's a subject, of course, to Ms. Van den Heever confirming,
Yeah.
but I had understood that the proviso was file on the 8th, subject to Mr. Matlala's right to supplement statement filed. That was the reservation made.
Because there could not be an undertaking to file, but at the same time not to file, an undertaking
yes.
not to file.
And in fact,
It's even wrong for me to refer to the latter as an undertaking, yeah.
And in fact, that proviso was discussed amongst ourselves because of the tight timeline they then had to file by, having missed previous deadlines. The only way to cure any potential prejudice to Mr. Matlala was to agree and place on record that he reserves the right to supplement. We thought it is a natural way to go, and he's entitled to supplement whether or not he has reserved that right in any event. But to the extent that it was necessary to articulate it in no uncertain terms, we were agreed to that. So that was the proviso, Chair, that was attached
All right.
to the filing.
Please continue.
Thank you. So at the end of the day, what the legal position is regarding Mr. Matlala's constitutional rights, as posited by Leonard Friend, is irrelevant for our purposes. She may very well be correct, she may very well be wrong, but it doesn't advance the issue any further. Those rights existed on the 7th when she made the undertaking, unless she suggests that they have since or very recently been earned. I listen carefully and I resist the urge to argue that this is a moving target. And each time we think we've got the target, then that target is going to move. And we are continuously chasing a rabbit we cannot catch. And Chair, I implore you and commissioners to please put an end to this. Witnesses come here and make undertakings. They give dates. We work on a very tight time schedule. Either witnesses respect the rulings given by the commission and adhere to those rulings and file, or either appear on the dates that have been either directed by the commissioners or on which they have made undertakings, because otherwise it makes the work of the commission impossible. We now have to change things about. We now have to find another slot for Mr. Matlala. We now have to plan for him when to give an affidavit, a statement, and to find a slot. And all this time, it's in circumstances where this commission has got a limited time span left to it. I am concerned about the approach being adopted by Mr. Matlala's representatives, and I don't think it is particularly appreciative of the challenges that the commission faces. As to whether or not the commissioners and the chair will permit the rulings handed down to be wantonly disregarded as for the commissioners to decide. But I wouldn't be surprised if the commission holds a dim view of that. So, the difficulty we have, or I have personally, listening, is, and I do accept that I possibly misunderstand Ms. van der Heever. The plea agreement with IDEC, the aborted or stillborn plea agreement with IDEC, at the risk of stating the obvious, that has got absolutely nothing to do with this commission. What this commission is interested in is its terms of reference. It's interested in the issues that were raised in the Rule 3 notice that was served on Mr. Matlala, as well as the subsequent Regulation 10.6 notice. That's all where this commission is interested in. I'll rephrase that. That is all the evidence leaders have indicated they are interested in. The commissioners may expand those issues. What position Mr. Matlala assumes in response thereto is his choice. We desperately do not want to be a part of a discussion on how does he respond to a particular question. If a question posed invites a defense, a Section 35 of the Constitution defense, so he must state, and then we will deal with the defense as raised when he appears.
And as I put it to Ms. van der Heever, it cannot be that everything he could ever say is covered by or by Section 35.
Indeed.
Or bears relevance to the Section 35 protection. It can never be, and Ms. van der Heever accepted that.
Yes, Chair.
And facts are facts, and they should not change in accordance with whatever it was that went on under the plea deal. But as Commissioner Baloyi said, that's null and void anyway.
In any event. And once again, it depends on whether I understood her correctly. It gets worse because now it sounds like the commission shall be hamstrung by any plea deal that Mr. Matlala may choose in any criminal trial, whether ongoing or in the future, to conclude. So, effectively, if Mr. Matlala were to tomorrow face 5 charges in five different criminal trials, and he considers whether or not to conclude a plea deal in any one of them, then this commission is hamstrung, unless I completely misunderstood Ms. van der Heever. My understanding would be, I don't believe she would suggest that. But at the same time, then I struggle, what exactly is being suggested regarding these plea deals? And once again, I have no clarity. I submit, commissioners, that the only position to assume is we have nothing to do with any plea deals that Mr. Matlala chooses to conclude anywhere in any court. He has 2 defenses in this commission. It's a Section 35 defense, or buttressed, in fact, by Section 8, sub 2 of the Commissions Act, that anything he says that would incriminate him cannot be used against him in any criminal case. So he's got 2. He can raise them. So why we are having a debate about plea deals and whether or not his legal team understands the facts that underpin such a plea deal is a challenge to me. Now, the offer, mindful of the time, made to file in 2 weeks, I can accept. In any event, it's up to the commissioners. However, the offer, if I understand it correctly, sounds to be conditional, and this is what the condition is. It's dependent on whether or not they get the requested information from either IDEC to enable them to answer the questions posed. If I misunderstood, because I think Commissioner Baloyi indicates there's shaking her head as if I misunderstood her.
I think the ultimate position was they will file a statement.
If it is wholly unconditional by a specified date, then I'm happy. Because my concern was that if they do not get the required information from IDEC, or IDEC just outright refuses, then they would be entitled in law to approach a court to compel IDEC to provide such information if they have a basis in law to do so. And if that court case is unfavorable to them, there are appeal proceedings. So the question would be, do we await that information and the challenge to right to that information to run its course until the Constitutional Court before we get a statement? But I will accept what Commissioner Baloyi says the filing in 2 weeks is unconditional. If that is the case, then we just need to set a date. And if the statement is not filed, we shall be back before you, Chair. And I suggest that the consequences will follow. What then must happen now is to lock in a date, as we did of the 15th that has now collapsed, as to when Mr. Matlala will appear. And I say so because we as the evidence leaders have to go rejig our program and accommodate the new dates, while at the same time making sure that there is sufficient time for everybody to prepare for Mr. Matlala's appearance before you.
Would the preference be for the postponement to be to a specific date or a date to be determined?
No, Chair, I would prefer a specific date at this point.
Specific, all
Yes.
right. All right, please continue then.
Thank you, Chair. And to assist perhaps the commissioners to consider a possible date, my learned friend will confirm, I understood that the upcoming trial that starts on the 20th.
Just a minute.
Yes, Chair.
I think on your last point about the date, I think it would be better for you and Ms. van der Heever to engage, and then, which of course would necessitate a stand down. And when we come back, hopefully, we'll get an agreed date.
Oh, no, I'm happy with that approach,
yes.
as long as I come out of this hearing with a ruling on a date. Chair. However that point is reached is irrelevant. I'll accept that, Chair.
Any further submissions?
No, Chair, I think that will suffice. I'm looking at the time. As the commissioners are aware, there's another administrative issue to deal with before my witness returns to complete his testimony.
Any reply, Ms. Panel?
I'm going to be very brief, Chairperson.
Yes.
I'm not going to go back to the issues of the plea deal. I've got experience in that regard, and I know it's important. And at some point in time, I will demonstrate to you what the importance of that is.
Yes.
The second thing, my learned friend says that subsequent to the date of the 7th, nothing happened. The affidavit sets out quite clearly what happened subsequent to the 7th. The 13th, we were back in court. There's also the issue on the 8th, the recordings were disclosed and what happened there. So my learned friend is not correct when she says there's nothing. It's been set out chapter and verse what transpired from that date on. And the thing that's quite important, Chairperson, is I don't believe this commission, and I've said it before, as you recall, we're not here to ambush witnesses. And it's for that reason that I'm entitled to ask, if you're in possession of certain material that you wish to use against my client, I'm entitled to ask for it. Because that way, we level the playing field. So that also needs to be taken into account. Lastly, you were quite right. I did reserve my right twice.
Or just before you move to a different point, wasn't everything that Mr. Matlala required given before the 7th of July?
We said that there must be certain recordings. We then given 13 voice files. We then said it's clear somebody went and extracted, like cherry picked and given us 7 voice files. We now want the complete recordings from which these were extracted. We were then given on the 8th, I think, recordings, 2 recordings. There's in fact a 3rd recording that was not given to us. Then we were handed over, I discussed it with my learned friend, and she made some inquiries. We were given a transcript, an unofficial transcript of the one. So, and these are long. The one is 6 hours and the others together is longer than that. So, and the client must sit and listen to it because he needs to ensure himself. So that process wasn't even concluded. And then lastly, as I said, it's just an issue of, I did reserve my right because I foresaw what was going to happen at that point in time. It was not a condition I will file and then amplify. I just couldn't because at that point I still hadn't had any access to the client to discuss any of the issues relating to, as I said, let's call it the Medicare 24 matter. One more thing, Chairperson, I'm going to ask you and the commissioners to consider the following. I'm going to ask that we be assisted and that an order is made that we get access to the client over weekends with electronic devices, in other words, with the computers, to assist us in dealing with all of these things. It's very difficult if we can't do that. It's the times that you can see the client is limited. There's only a limited number of legal practitioners at any given time that can see the person. And if you were to see in the normal way, there's a thick glass and you can't listen to recordings. So we would like, if there's any way that you see open, that we be allowed for this weekend and the next weekend to get access. After that, we won't need it because the last weekend would be just before the filing. Because we're also starting on Monday, he gets transported, very limited time in court because we're running the trial. So what we can do is we can get drafts exchanged that he can look at that, but to finalize it, we'll also need to have access to him next weekend at the prison.
How is it done for purposes of the criminal trial that's commencing? Is it next week?
We've had consultations long before. It's actually a much simpler matter than anybody has made it out to be. And that's why for that it was easy. We've given the client the dockets that was disclosed, and when we had opportunities, we've discussed with them our defense, our plea. So that was, and we had two person-to-person meetings that was allowed by the head of the unit. So we could actually go in with computers and have those. But for some reason, I think because of what has been transpired, we are not getting access that easily anymore. I can just speculate why suddenly, after things have started going a bit differently. So all I'm asking is if you can assist us in that regard, we'd appreciate it.
Yeah, I think something like that would have to be dealt with administratively. I cannot make a ruling here. But anyway, it's not that I understood you to be asking for a ruling. Because, for example, I do not know what prescripts correctional services may put up and say, we can't comply.
No, so all I'm basically asking
but that should never be understood to say, after agreement on a date, what happens or does not happen will then be a basis for saying, no, we are not able to file because. Please continue if there are further submissions.
Simple, we will do our best, but maybe something from the Commission side that we should, without making a ruling, that from DCS side that they should do whatever they can to assist us. I think that would go a long way. That would give us something in the hand to now go and do from our side what we need to do. Thank you. I've got nothing else.
Nothing else.
I agree with my learned friend then that we discuss inter partes the date.
Yes, all right.
Ms. van der Heever, without getting into it, I just want to know its status. The opinion letter, I'm not getting into it. Was it filed just for the purpose of today's postponement? It was to deal with just today.
Oops, it doesn't work anymore. Oh, there it goes. It was done for today because of, as I said, that's all I wanted to say.
Yeah, it doesn't go beyond.
There are other reports and things that's available, that's been drafted. We have been communicating with the head of prison with regard to the issues, but I don't want to go into that further at this point in time.
It was just for today's postponement.
For
That's
today,
all I wanted
and the relevant part of it, you'll find about the issue of. Yeah, I mean, you've read it.
Leave it there. That's fine. Thank you, Mansard.
Chair, if I may, for the record, to correct for the record and posterity, Ms. van der Heever speaks of being provided with random extractions from recordings. That's wholly incorrect. The recordings that were provided were recordings that were played in this commission during the testimonies of witnesses. As we do when we provide our Rule 3s, we provide the evidence that implicates the particular witness who served with a Rule 3. Those are the 13 recordings that were played in here. They were not random. Nobody went into the recordings and decided they liked the sound of the clipping from 1 hour 15 to 1 hour 17 minutes. So that is one. Those were provided on the 18th of June. They were given to Mr. Matlala. It is only on the 7th of July, after the ruling, and their statement is due the next day on the 8th, that they require the complete recordings. And they were duly provided on the 8th. So it is not like information was denied them or we failed to respond positively to any request for information made. Each time it is made, it is given. The inescapable conclusion is nobody listened to those 13 clippings when they were provided, and because if they did, they would have made the determination at that time already that they require full clippings in order to prepare a statement. Thank you, Chair.
Maybe that just on that issue, Chairperson, what we immediately on receiving those recordings send it off to an official transcriber. It was in vernacular. It then had to be typed up and then transcribed. And then upon seeing the client with the computer, it's only then that we realized that these were extracts from various other recordings. And it was only at that point that we could approach the commission, the evidence leader, my learned friend, and say we want the full recordings, because we were then informed that it's extracts from other recordings.
We will, thank you to both of you. We will, let me just look at the time. We will adjourn and come back when you tell us to, and we hope that we'll be within a very short time. We are not taking the tea break at this stage.
Noted, Chair.
And this is for a discussion between the two of you on the date of the hearing and two, the date of the filing of Mr. Matlala's statement.
Thank you, Chair.
Let's adjourn.
All right, we are ready to resume. Please make sure that your devices are quiet. Put them on silent. Thank you.
In hindsight, I think we should have taken the tea break because we are going to lose a lot of time now. Yeah, instead of hanging around outside, which is what we did. Anyway, let me hear from both council.
Thank you, Chair. I agree with you. Perhaps we might as well have taken a tea break. It took, the negotiated settlement took longer than we had anticipated, but we think we found each other. So this is the agreement we have reached going forward, and we would request a ruling be made in that regard, that Mr. Matlala's statement shall be filed on or before the 29th of July, 2026, and that his testimony is stood down to starting the 1st of September, 2026. So the hearing will commence on the 1st, and depending on the issues that we have to engage with, that could run into subsequent days. We would request that we do not commit to specific dates thereafter, but there's an appreciation that we are not fixing one day of the 1st. It's from the 1st. Thank you. Thank you, Chair.
Ms. Lo, is it the understanding between you and Ms. van den Heever that if we need to roll over to the next day, we won't run into diary issues that Ms. van Heever had not prepared for that?
Exactly, Commissioner Baloyi, and hence I express his date of appearance as from the 1st. So the agreement is the 1st and succeeding days as much as are required in that week. But I don't want to give, I won't say the 1st to the 4th, it could very well be, but we start on the 1st until he concludes his testimony, uninterrupted. Thank you.
Thank you.
Chairperson, I indeed confirm that that is the agreement. My understanding is that we start on the 1st and then it will continue until such time as we've reached the end. If I may just use an opportunity to just deal with one issue. I got a random message from somebody on my phone telling me that I'm not allowed to shout at you, Chairperson, or the other commissioners. I just want to make it plain that I don't shout, I just speak very loudly. Most people know that. So I am sure you didn't perceive it as shouting, neither yourself nor the other commissioners I spoke to. Just for people that don't know me, I speak very loudly. It's not shouting. Thank you very much, Chairperson.
If it gives you any comfort, Ms. van den Heever, let me tell you that a judge, when I was appearing in the Mthatha High Court, once shouted at me saying I should not shout at him. So.
Then we're in the same boat, Chairperson. I'm very happy to hear that. Thank you.
Thank you. One other thing, at least based on the agreement that has just been conveyed to me, I assume that you will not be insisting on reasons for the fact that we are saying the hearing will be continuing.
I do not need
Thank
any
you.
reasons. May it please you. Thank you.
Thank you, thank you. I thought I should just take care of that because there was the muted reference to the possibility of a High Court application. So one might say no reasons were ever given for an application that we made.
Like they say, I don't roll that way, Chairperson.
Thank you. I make the following ruling. Mr. Matlala must file his statement not later than 29 July 2026. And that's one. Two, the hearing of his testimony is postponed to 1 September 2026 to continue until the hearing has been finalized.
Thank you very much, Chairperson.
Thank you.
Thank you, Chair.
Thank you. Mr. Matlala, Ms. Vandenheever, you are excused. And because we are continuing with you, Ms. Sillo, you are not excused.
Chair,
Is it?
it's not with
Oh,
me for the
later.
next admin issue, yes. So only thereafter I come
Still
back.
you are with us later in the day, of course.
Yes,
But
thank
thank you. Let's adjourn and come back at midday, 12.
Thank you, Chair.
morning, Mr. Shaskalson. Good morning, Mr. Premhead.
Morning, Chair.
Morning, Chair. Morning, Commissioners. Chair and Commissioners, you'll recall that 3 weeks ago, Mr. Karim was postponed to today's date. He's not here today, and we received a doctor's note yesterday that refers to his admission to hospital on the 17th of June, which is more than a month ago. When we received that doctor's note yesterday, it seemed to explain Mr. Karim's apparent inability to appear today, but it didn't explain his inability to answer, at least in part, the Regulation 10.6 notices that had been served on him and that I addressed in the Commission 3 weeks ago. You'll recall, Commissioners, that we're still waiting for Mr. Karim to tell us, for example, who the auditors of his companies are. There's nothing in his doctor's note that suggests that his health conditions are of such an order that he's been unable to do that for 2 months. Similarly, we're still waiting for Mr. Karim to furnish audited or even unaudited financial statements for 3 of his companies, Ziggy, Tasmika, and Tamiz. There's nothing in the doctor's note that suggests he'd have been unable to issue a simple instruction to the officers of his companies to do this. And I want to emphasize here, we're talking about a group of companies, including Ziggy, Tasmika, and Tamiz, that have been paid hundreds of millions of rands from the Northwest Provincial Government and Northwest municipalities in the region of which he's the ANC Treasurer. Companies in this group continue to perform services for those organs of state and continue to be paid millions of rands by those organs of state. We're talking about multi-million rand businesses, not, family-run sort of small businesses that have to shut down if their owner is unwell. So if Mr. Karim took the trouble to ask someone, he ought to have been able to arrange that we receive the financials we've been asking for months now. That's where things stood yesterday. Mr. Karim seemed to have an excuse for not appearing, but he did not seem to have any excuse for failing to answer any of the questions in the Regulation 10.6 notice we sent him 2 months ago, and for not providing any of the documents we sought in that notice, almost all of which he had undertaken to provide when he testified when he was healthy back in, I think it was April. That was yesterday. And then after we received the doctor's note under cover of a letter from his attorneys yesterday, late in the afternoon yesterday, we received 2 different whistleblower reports, both confirming that Mr. Karim and an entourage had been seen yesterday going out for lunch at a shopping centre in the Western Cape. The 2 reports corroborated the same details. They seem to be independent of one another, and they've now been confirmed by eyewitnesses at that shopping centre, who we have independently contacted. So we now have it from multiple different sources that someone who seemed very much to be Mr. Karim arrived at the shopping centre with an entourage, went into Woolworths before going off to have a late lunch at a restaurant in the shopping centre. We've subpoenaed CCTV footage from the shopping centre, and we expect to have it received, and we expect to have it thoroughly analysed by midday tomorrow. For now, we have a concern that Mr. Karim may be taking liberties with this commission. And that concern is amplified by other whistleblower reports that we've received indicating that Mr. Karim has been seen at social gatherings in the Northwest over his period of ostensible incapacity. So we are going to issue a subpoena later today to the hospitals at which he's been receiving treatment to establish when he was admitted and when he was discharged, since he testified at the commission. We're also going to be issuing a subpoena to his doctor, who's based in Cape Town, to establish the dates on which he has seen Mr. Karim. And we don't expect that it will take us more than a day to obtain this information. And what we would like is for the matter of Mr. Karim's appearance, or non-appearance, to be stood down until Friday morning, or maybe Friday lunchtime, when it can be considered on the basis of a formal postponement application, which we would ask this commission to order him to bring by 10 o'clock tomorrow. The evidence leaders will reply to that postponement application by 6 p.m. tomorrow, and it could be heard by Friday morning at 9:30. If Mr. Karim's legal team needs more time, if we can have that postponement application by 5 p.m. tomorrow, we would undertake to respond to it by 10 on Friday, and it could be heard on Friday afternoon, not Friday morning. But what we do expect the postponement application to address is at least the following issues. The dates on which Mr. Karim has been admitted to hospital over the last 4 months, the dates on which he's attended medical consultations over the last 4 months, his travel movements over that period, whether he's attended social engagements over that period, and whether he's played any role in the management of his businesses over that period, and if not, who's been responsible for these businesses which continue to turn over in his absence.
Ms. Jaskelson, can you please add one more thing? I'm interested to know how he traveled from the Northwest to the Western Cape. Did he book flights? Did he fly there? Because if he can give instructions to people to book flights to him, surely he can give instructions to people to give you the names of accountants. Thank you.
So that is our request, Commissioners, that the matter stand down to be decided on the basis of a formal postponement application on Friday.
Thank you, Mr. Shoskelson. Yes, Mr. Premier.
Good afternoon, Chair. Good afternoon, Commissioners. 5 brief points in reply, if I may. Firstly, do you have the Commission's correspondence bundle? I was handed one about 10 minutes ago by a Commission representative, but it's called Karim Suleiman Correspondence and Sundry Documents Witness Bundle. I'm going to refer you to the confidential medical report in that. I'm not going to discuss the contents, but if you can turn up page 128 of that medical report, when you read paragraph 1 of that report, that will deal with my learned friend's contention that there's an inability to explain attendance. And when you read paragraph 2 of that same report, particularly lines 2, 3, and 4 of the second unnumbered paragraph, that is a direct response by a medical practitioner as to why, potentially, there's an inability to give answers. So insofar as my learned friend says there's just no explanation at all, that's contradicted by the medical evidence of an expert in a particular field of medicine, which my learned friend is not. That's point number 1. Point number 2, my learned friend must choose his words very carefully with all due respect, because my learned friend talks about hundreds of millions of rands, companies that are continuing to service the state, multi-million rand businesses and so on, and he uses the quantum of my client's otherwise legal business to evidence some or other gratuitous behavior in front of the Commission. Until such time that a court orders otherwise, that there was unlawful business dealings with the state to the tune of those hundreds of millions of rands, the fact that there's business that may or may not be done to the tune of hundreds of millions of rands is neither here nor there. So my learned friend must choose very carefully his words in elevating otherwise perfectly legal facts to be weaponized into some sort of smear, potentially, against my client and otherwise lawful activity. The third point that I would say, in respect of Mr. Karim's undertakings to give the evidence, is you'll know that Mr. Karim, if you'll give me 1 second. I'm indebted to Ms. Matlangwane. On the 13th of April, suffered the medical incident, and at least on our version, he has been in medical treatment since then. And so his ability, notwithstanding undertakings whilst given in the box, must be construed having regard in particular to that second paragraph that I referred you to on page 128 of the bundle. Can I say, in number 4, in respect of these whistleblower reports and the alleged corroboration or not corroboration that has occurred or not occurred, and this is a two-part point, so you'll forgive me. The first part of which is we only learnt about these facts today. I know my learned friend says he also only learnt about these facts today, but apparently these social gatherings were known about before. And it's the first time we're learning about these things today, and I must place this on record, in as much as I don't for 1 minute question my learned friend's ability to rely on those allegations to raise a question about Mr. Karim's position in front of you. We would respectfully submit, and I know earlier there was an exchange about whether respectfully is respectfully or not respectfully, but I'm respectfully submitting.
I'm happy you were listening.
Yes, no, the commissioner is warmed up by the time I come here, so I know what I'm walking into. The point that I would make is that it's unfortunate we're learning about these in an open proceeding of this kind, and that these demands about what this formal postponement application needs to entail in an open session of this, rather than to have had an opportunity, even after either a stand down or a postponement was asked for today, given that the client is not here because he's presently in the hospital. So it's unfortunate we've learnt about it in this way, but my learned friend and I throughout the morning have been talking intensely about what he can give me and what he can't give me, and whether he's going to give me the CCTV footage he's already got in his possession or he doesn't. Well, I don't think we're in agreement on that, but my learned friend very kindly my learned friend has very kindly given me the license vehicle registration of the vehicles that were apparently transporting my client or not transporting my client yesterday, and we'll deal with that in due course. All I'm saying is that the manner in which we've learnt about this is regrettable, and the reason it's regrettable, and this is the second point of my fourth point overall.
How do you suggest you should have learnt about it?
That is a segue, thank you, Chair, to the second point I want to make under this, is that with all due respect, I'm now concerned that we are inadvertently using the postponement application and the allegations regarding the movements of my client or otherwise as a mechanism through the back door to undermine the otherwise unimpugned medical evidence in front of you. And Chair, you asked me how should we have learnt about it. With all due respect, I don't think it's for my client necessarily, unless you order otherwise. If you order it, well, then we have to do it. But if you don't order it, it's not for my client, with all due respect, to answer these accusations in the ether in the way that they are, where the overall purpose or effect is to create doubt about the medical excuse.
That's a different issue. You raised an issue, or rather, you complained about having lent of the information in the manner in which that happened. So I'm asking you the question, how do you suggest you ought to have gotten to know about the information? That's different to what you are saying.
Yes, Chair, thank you. The way in which we should learn about it, and I know Chair says to me it's a different issue, I will respectfully say it's not a different issue, is because if the purpose or effect of that accusation is to raise doubt about my client's medical condition and whether there's a legitimate excuse for his attendance or non-attendance at the commission, because that's what the sting of that accusation actually is, then actually the shoe should be on the other foot, in the sense that it should be the commission, the evidence leaders, bringing an application where they raise this evidence in the round of questioning the medical advice or otherwise, or the medical reports or otherwise that have been tabled in front of you that otherwise serve as the excuse. It's not the hill I'm going to die on. All I'm simply saying is that I'm concerned that the way in which these accusations now have to be dealt with is almost reversing the onus that otherwise falls on my client.
That still doesn't answer my question.
I apologize, Chair.
Yes. The question of how Mr. Karim must respond is something other than your suggestion about, maybe the word I'm going to use will be strong or too strong, the impropriety that you suggest with regard to how you came to know is what I am addressing. That has nothing to do with how Mr. Karim then deals with the information. So my question is, how do you suggest this information ought to have landed on your or Mr. Karim's lap?
In writing and particularized, so that it's formally placed in front of us, rather than as what happened between my learned friend and I, which was a conversation between colleagues regarding these issues that are now being raised. So that's when I talk, and Chair, with all due respect, impropriety is a far higher word
That's exactly
Yes.
why I
Yes.
said maybe it's too strong a
Yes,
word. Yeah.
because I'm not,
But,
I'm not accusing my learned friend or anybody of impropriety. I'm just raising my concern about the manner, and then that's the direct answer.
Maybe instead of impropriety, I should have said concern,
Yes.
which is the word you've just used now.
Yes. So Chair, I think we're ad idem then that it's concern, not impropriety, and formally in writing, because these are very serious accusations, and I understand that my learned friend is under his collegial obligation to give me notice that he was going to raise it today at the hearing, but he could have perhaps, we could have reached some or other arrangement about being informed about this formally and then given an opportunity to respond. But we are where we are now, so that's water under the bridge, I suppose.
Yeah, I was going to say, why is it that the informal advice cannot serve the same purpose as written advice?
Well, I suppose because my learned friend is not the witness. So when my learned friend, and neither am I. So when my learned friend says to me, you know, these are the core of the allegations, it might turn out that some or other detail about that is going to change or not change, and there should never be a dispute between my learned friend and I as to what he said to me or what he didn't say to me. I mean, if my complaint is at this point only boiling down to housekeeping about the form of communicating the information, I accept that that might not be an issue which needs to detain the Commission.
The issue, as I understand it, is not so much about the interaction between the two of you. It's about Mr. Karim addressing what we are told has since been discovered.
Yes.
So the focus is less about the interaction between the two of you.
Exactly.
And the point being, if indeed it is true that Mr. Karim was at some food outlet out of town, I think reference was made to his vehicle or vehicles, I'm not sure now whether one or two or more. So point is, when you apply for the postponement, why is it, or rather when he, Mr. Karim, applies for the postponement, why is it that he should not, in the application for a postponement, deal with those? If he says, I was never out of town, I was never at this alleged food outlet, and therefore, my medical certificate stands, and it is to this effect. Nothing has changed. I do not see what the hurdle is, Mr. Karim, dealing with the new information on that basis.
Agreed, but I think that's also I'm sorry, Chair.
Yes.
May I respond?
Yes, please.
Thank you, Chair. But that's the point, with all due respect, is that, remember, when we arrived here in front of you today, it was on the basis of what was known before my learned friend disclosed the new information.
Yes.
But now what's happening is new information is being introduced, which may need to be dealt with to justify future postponement, but the basis upon which we're here in front of you today is the different historical facts, not the new facts introduced now.
But that's exactly why Mr. Karim is being afforded an opportunity. And it's not as if Mr. Shaskalsin is saying, and we want Mr. Karim to deal with this now. No. And that's it. Mr. Shaskalsin is suggesting to the Commission that Mr. Karim must be afforded an opportunity to file an application / affidavit dealing with these developments. So, in the light of that, I would suggest to you, subject to what you say, in the light of that, it should not matter much what you originally came here for today. Things have changed, and because things have changed, Mr. Karim is being afforded an opportunity. So unless other submissions are made, I do not see what the unfairness to him would be. Mr. Karim, because of these developments, bring an application which will be heard on Friday at whatever time. It could even be in the afternoon, and deal with these developments. Tell us why you are not able, for example, to provide the Commission with the information it required, or to give the necessary instructions to whoever may do so, to give the Commission that information. So in that application, he must deal with all of that.
That's why.
And issue, as I understood Mr. Shaskalsin being, this information was requested a long time ago, and Mr. Karim has not provided it on the basis that he is not well. Now, these developments referred to by Mr. Shaskalsin, at face value, suggest that Mr. Karim is going on about his life. That raises the question, if that be so, and underline if that be so, how can it be that he is not able, either himself to furnish that information or to do so through others? And he's afforded an opportunity to respond and say, I cannot, I simply cannot. And to do that, and to move the application on Friday. I'm not saying that's what we are going to rule, but that is what Mr. Shaskalsin is submitting should happen.
Yes, Chair, and I accept that. That's why,
Yes.
that's why I placed manner and form no higher than a concern, rather than using that favorite A word of ambush, and also claiming trial prejudice and fair trial rights. I was, with all due respect, simply placing on the record a more subtle concern from my client. That's all. And that's why I've resisted putting it higher than that. May I just say that in respect of the face value concern and the timing of the evidence and the way Chair posits to me what Mr. Chaskelson put to you, Chair, you've already heard me on that page 128 paragraph of the bundle as the explanation. But insofar as and this is now...
Please take me to the relevant lines of the first paragraph. The first substantive paragraph, not the intro.
Yes,
Yeah,
the first substantive paragraph is about whereabouts. So that's inability to attend, to use my learned friend's phrase.
In respect of the second paragraph,
yes,
you referred us to specific
the explanation,
lines.
yes.
Specific lines.
If you look at the second sentence beginning on line 2...
Starting after. We're not going to read it.
No, we're not going to read it, indeed
But
not.
is that the one starting after?
No, given.
Oh, given.
On my side, I have given.
Okay. All right.
I'm indebted to Commissioners Baloy and Kumalo.
I thought you referred to the first paragraph as well.
Yes,
So I had no problem at all with the second or the last paragraph.
Yes.
So what I was raising with you was, please direct me to something on the first paragraph. So are you saying you said nothing about the first paragraph?
The Chair, just to be clear.
The first paragraph starting Mr. Karim.
Well, the problem is they both start Mr. Karim.
Oh, let me look. Has been. The big paragraph.
Okay. So
Mr. Karim
the
has
bean
been.
paragraph, if we
Yes.
can call it that.
Yeah, do you have lines you want to refer
No.
to
In
there?
the bean paragraph is the whereabouts explanation.
Okay,
And if I have to point you to particular lines, I would say from the date mentioned in
Okay.
3, running on to 4, as it continues. And then there's an
Okay.
explanation there which I don't need to go into.
Okay.
And then in the second paragraph,
Yes.
the remains paragraph, not the been paragraph. In that paragraph, I would ask you to look at the second line, the second sentence starting given. And I would say that that second sentence, which runs on to line 4, ending before the word his, is the critical one regarding inability to explain. The third sentence, which starts his present, that also adds color, but the critical one is the sentence I've highlighted. So that's the face value explanation. That's the response to Chair's point about face value and explanation. But Chair, can I, on my fifth point, I said to you 5 points briefly. It's not that brief, but fifth point briefly, is the timetable. I've heard my learned friend where he's given 2 options for the timetable. He says 10 o'clock tomorrow, reply by 6 o'clock, Friday 9:30 for argument. Alternatively, if I'm not mistaken, he said 1700 hours tomorrow, 1000 hours, they'll respond the next day on the Friday, I think, and then we'll argue on the Friday afternoon. Can I just make 2 points about that? Obviously, the first one is obviously we're in your hands regarding your directive and the timetable for the hearing of that application. Before we entered the room, I did specifically ask my learned friend if he would consider our ability to have that argument next Friday, because you will know that in the correspondence there's consistently been the issue raised about our ability to take instructions directly from Mr. Karim and having to rely on the medical practitioner and the family. And so there might be practically some delays in obtaining the level of specific instructions that we have to now obtain. But as I say, I'm in your hands on that. You will direct as you need to direct. The second point, and I think my learned friend and I have reached an in-principle agreement on this, but if I'm wrong, no doubt he'll correct me in reply, is that Friday, insofar as, I'm just using Friday as the placeholder date, Friday, insofar as we end up needing to discuss medical conditions, hospitalization dates, even identity of the medical practitioner and the speciality that they may or may not specialize in, obviously impinges potentially on my client's medical privacy rights, and also around causing unnecessary public, in an open sense, public speculation about his state of being or not being. And I've already flagged with my learned friend that we might need to be because for the exact reason that I can't read to you what the contents of the medical report actually says, I have to use all these sideways descriptions of directing your attention to content. It might be appropriate for us to have that debate at least in camera without the journalists and the outside world reading in, to the extent that we need to go into that medical history and the details. So never mind the timetable issue, Chair. I think in addition to, if you direct that we have to bring the formal postponement application in the way that it's posited, I'm giving advance notice to you as the Chair and the Commissioners, and I've flagged it and I've discussed it with my learned friend, and he was very understanding, I'm grateful, that we might need to then have that as an in-camera session so that my client's medical privacy rights are protected and his dignity is not unduly impaired as a result of what information we, as the Commissioners, the evidence leaders and his legal representatives, need to have a frank debate about in a way that still manages to protect him. So, Chair, those are, may I just check with Ms. Matlala, who usually holds the purse strings?
Yes.
Ms. Matlala says I've done my job, so it's fine. Thank you, Chair.
Thank you. Mr. Shaskalsin, any reply?
Brief reply, Chair. First, in relation to the businesses. Why I mention the businesses is not to say that these are unlawful earnings or that these earnings are, proceeds of crime or anything like that. It's to say there is a very substantial business group that is carrying on in the apparent absence of Mr. Karim. And if the group can carry on in the apparent absence of Mr. Karim, then it's not clear to us why we can't get, through a simple request from Mr. Karim, details like financial statements of 3 of those companies in the group, the identity of the auditor of 3 of those companies who we still haven't been able to ascertain from repeated requests to Mr. Karim. So if he can keep his businesses ticking over remotely from his sickbed, he can also issue an instruction that the information that exists external to him can be made available to us. And he hasn't done that for months now. The second issue in relation to the medical report is it's curious to hear my learned friends saying we haven't impugned the validity of the medical report, because last time we were here, you'll recall that there was a suggestion on the table that Mr. Karim should make himself available for independent medical examination, and we were told, oh no, you don't have the powers to do that. You're not a high court with powers under the rules, you can't do that. He won't make himself available without you, and you don't have the power to do that. So now we're told you can't examine him, you can't get an independent medical report, but when you have extrinsic facts which give reason to doubt that he is unable either to appear or to furnish information that you've asked, you cannot raise them because you're not impugning the medical report. Well, they can't have it both ways. If Mr. Karim wants to make himself available for our own independent psychiatric or other medical examination, we will do that. We will do that, and we will arrange that an appropriate specialist dealing with whatever medical conditions he has raised, which range across a very wide spectrum, are investigated and a report is furnished. Finally, I want to emphasize one particular misconception, and it is this. Mr. Karim comes here asking for a postponement without making a postponement application. We have information that makes us concerned about the bona fides of his claim to a postponement application. We are giving him advance notice so that his postponement application can address those issues on which he will have to satisfy the Commission. He seems to proceed from an assumption that he can have a postponement if he wants one, and it's for the Commission to show that he shouldn't have a postponement. It works the other way around. He needs to satisfy the Commission. And in order to satisfy the Commission, he's going to have to address these concerns that we've raised. That's why we've raised it. And that's why we've raised them informally, and that's why we've raised them in advance of a postponement application. In relation to the timetable, we have suggested Friday because we have had a succession of witnesses this week who were scheduled who have not appeared and who are not appearing. So scheduling this postponement application on Friday will no longer interfere with evidence time that we have scheduled. We've had, in fact, all 5 days of scheduled evidence, originally scheduled evidence, or 4 of the 5 days of originally scheduled evidence this week fall away because of postponement applications. So this Friday is not going to interfere with scheduled evidence time. If we get to next Friday, we will interfere with scheduled evidence time. And the debates in relation to Mr. Karim's evidence and appearance and non-appearance have thus far taken up days of Commission hearing time, and we don't have days to waste. So we want it done this Friday because this Friday currently is a day which is sitting fallow. As far as the in-camera concerns raised by my learned friend go. If there are legitimate concerns in relation to privacy, we are happy to accommodate them, but whatever happens in that regard needs to be tailored very tightly so that any in-camera process is confined to that which is necessary to address the privacy concern. Those are our submissions, and we would ask that this postponement application be brought on a timetable where we can give the extra time to our learned friends. They can file their papers by close of business tomorrow. We will respond by 11 o'clock on Friday morning, and the postponement can be heard on Friday afternoon.
Chair, excuse me, Chair, may I seek, firstly, as a matter of protocol, may I seek an indulgence to address you on one point that I must respond to that was raised by my learned friend. It's this point about my client can't have it both ways, about the independent examination on one hand and then subpoena the doctor. You will remember in that general discussion we had the last time, it's not one or the other. My client placed on record that the power of independent examination is open to serious doubt. And you'll remember I explicitly said, I used the phrase, there are less intrusive means that are available to the Commission if there's a doubt about the medical evidence, and the subpoenaing of the doctor is one such option. So there is no inconsistency between what I have said to you today and what I have said to you previously, and that's as far as I'll take it. Thank you, Chair.
Thank you. On this, Mr. Oh, sorry.
Mr. Premier, I understood Mr. Chaskalson to simply be making the point that you are not correct to say this medical certificate has not, no doubt has been cast on it. And all he was saying was, we have said he should go for an independent examination. That's the only point I thought he was making.
Then please strike what I've just said from the record if I was incorrect in my understanding of what my learned friend said. I just wanted to make sure on the record that there's no ground to suggest an inconsistency. And that's as far as I'll take it. Through you, Chair, obviously. Thank you.
Thank you, Mr. Premier. I guess there's no need to respond, or is there, Mr. Chaskalson?
No, Chair.
Thank you. Just one aspect. I assume that the several issues you itemized are the sort of issues that would have to go to a ruling or the ruling. Or not? Remember, you itemized a few.
Yes, I've certainly itemized. I'm not suggesting they should go into an order, but if they aren't responded to in the, if they aren't addressed in the postponement application, we will ask the Commission to draw its own inferences.
We proceed on the basis that Mr. Karim, through his legal representatives, has heard the issues that you itemized.
Just in fairness to Mr. Karim's legal representatives, maybe I should run through them again. And what we were asking for was the dates on which Mr. Karim has been admitted to hospital over the last 4 months.
Just, I see the paper is being sorted out, and I think when you started, they were not ready yet. Please, Mr. Chaskalson. Yeah.
The dates on which Mr. Karim has been admitted to hospital over the last 4 months, the dates on which Mr. Karim has attended medical consultations over the last 4 months, his travel movements over that period, how he traveled to Cape Town in the last week, if indeed he or beforehand, if indeed he has traveled to Cape Town. And it seems that he has traveled to Cape Town because one of the medical reports speaks to hospitalization in Cape Town.
Mr. Chaskalson said they have information that he has been traveling from the Northwest. So I know that there's no airport in the Northwest, so unless he drove to Cape Town, I'm assuming he would have flown from either OR Tambo or the other airport. I can't remember what it's called for now. So that is relevant to me, because if you can give instructions to anybody to book flights for you, then you can give instructions to those who are running the business to provide the detail the Commission is looking for.
Yes, thank you. Thank you, Chair and Commissioner Kumalo.
Oh, just, yeah. Perhaps, before, I'll give you a chance, Mr. President.
I was saying thank you for the clarification and the amplification as to the travel arrangements, because my learned friend said travel arrangements broadly, but Commissioner Kumalo has a specific travel arrangement in mind that needs to then be dealt with. That's what I was saying thank you for.
Thank
I'm
you.
indebted to Commissioner Baloy.
Thank you. And Mr. Chaskalson, perhaps it's best for you to just give a piece of paper to your colleagues.
I'll do that immediately after the
Thank
hearing.
you.
Mr. Chaskasan, you have narrowed down his activities, business activities, to management. Can I suggest that it be in the business affairs and not narrow it down to management, because management could easily be interpreted as being purely operational. And what we would like to know is what has been his involvement, if any, in the affairs of his businesses. Thank you, Chair.
I'll do so, Commissioner.
There is the matter of detail around the exact timing about filing, for example. Let's leave you and Mr. Premier to discuss that detail and even the time when the application should be heard. But let me upfront say that the decision I make is for that postponement application to be heard this coming Friday. But the question of when exactly tomorrow the application should be filed, when the answering affidavit should be filed, and the exact time at which the application should be heard on Friday, may I ask Council to please discuss that. And once you have agreed, Mr. Premier is excused, and Mr. Chaskalson can just bring that to our attention, say after lunch, and a ruling then gets made.
Thank you, Chair. We will do that.
Chair, may I please just ask a clarity, and I'm sorry to do this, but you'll remember on the last occasion when I argued for an in-camera application in front of you, part of my submissions was to say, well, the horse is already bolted, because in trying to justify the in-camera, we went to the details. I've already flagged the fact that there's going to be a request for in-camera. Obviously, if the Commission, through the evidence leaders, opposes that request, that's a different story. I'm just flagging now that come Friday, it's not just the postponement that might need to be determined. There would also need to be consideration of the in-camera and how it is going to be argued in front of you in a way that balances.
If in the light of what Mr. Chaskalson said, which I thought was quite accommodative, if that will still be an issue, let's consider that if and when it arises.
Perfect. I'm indebted.
And Chair, can I suggest something else, that pending Friday, this Commission issues a ruling essentially stopping speculation about Mr. Karim's trying to contain speculation about Mr. Karim's medical condition pending Friday, because the issue is going to be, I don't know how to formulate it, but I do think that there is a risk that coming out of today's hearing, there may be wild speculation in the media. Can I speak to Mr. Premier about that, and when we come back to you with a timetable, we will do that. We will include a proposal in that regard, but it may be, I don't know how we take that further.
On the last point you made, Mr. Shaskalsin, may I say, please make it part of the discussion, and let's see what comes out of that. We are subject to what Ms. Silo says. We are minded to take an early lunch and come back at 1:45. But of course, we will hear Mr. Shaskalsin first. If Mr. Premier will not be coming back for whatever issue he might still want to address. If there's agreement and there's a draft ruling, then Mr. Shaskalsin will come back and...
I'm indebted. That's very kind. Thank you.
Yes. I've just been overruled, and the suggestion is for us to come back at 2 p.m. We'll adjourn and resume at 2 p.m. Let's adjourn. Mr. Chasselson?
Thank you, Chair. Mr. Premier and I were happily able to reach agreement relatively easily. I have an agreed ruling. Unfortunately, I've had printing difficulties, so if I might read it out to the Commissioners. The first paragraph is that the postponement application is set down for hearing at 1400 hours on Friday, 17 July 2026. The second is that the application will be served and filed on or before 2000 hours on Thursday, 16 July 2026. Third paragraph, the answering affidavit will be served and filed on or before 1100 hours on Friday, 17 July 2026. And fourth paragraph, the replying affidavit will be served on or before 1300 hours on Friday, 17 July 2026.
A ruling is so granted.
Thank you very much, Chair. May
And
I
you
now
are,
be excused?
you are excused,
Thank
Mr.
you.
Chasselson.
Thank you, Chair. I have some technical challenges, Chair. There's a document I need to start with. I have it in my electronic version, and we are trying to locate it in your printed version. If it would help in any way, it's
Commissioner,
A32.
let me say this. Commissioner Kumalo has a way of finding documents for us.
That's-
Maybe what you should do is just to describe it sufficiently. He will probably find it for us.
That's exactly where I was going, Chair, to tell that it's A32. It's an affidavit by the witness seeking, I think, an arrest warrant. It's A32 in the docket. I have it, I can project it, but we're trying to find the file number and the page number for your purposes so that we work through it. And I've considered all possible clever means of doing so. And I must say that thus far, it looks very encouraging with Commissioner Kumalo, Chair.
Apologies if I've put you on the spot, my colleague.
But perhaps while we do so, I wanted to, it's midday, I haven't done the preliminaries, my apologies. Good afternoon, Colonel. It's as if we're continuing from morning.
Colonel.
Good afternoon, Chair. Good afternoon, Commissioner. Good afternoon, Council.
Good afternoon, Colonel. Good afternoon. Thank you.
Commissioner Baloyi had some questions for the witness, I think, regarding the Section 27. Yeah, Section 27 affidavit, I think, from yesterday. It wasn't finished. But I wanted to move from that to jump back to Section 27. But perhaps I perhaps should allow Commissioner Baloyi to deal with her issues regarding that affidavit. I'll come back to it. When I come back to it in my plan, that should work.
I appreciate how you're using me to buy time, Mr. It's not lost on me. You can start. I'll catch up. Yeah.
Thank you. If that's the case, then I would invite the witness to CJC 377. We've dealt with this before. It's in file 3 starting at page 681. And that is our A1 statement by Mr. Adams. CJC 377.
Chair, before we continue, may I just come and say, give some input? I think since yesterday, there were three things that I said I will be guided by you, Chair, on aspects, as we discussed, on confidentiality and the docket, which is currently before court. So what I want to bring to Chair's attention, the A1 state...
Sorry, I made a serious mistake. Good afternoon, Mr. Podlani. And apologies for not recognizing you or greeting you.
Good afternoon, Chair. Good afternoon, Commissioners. And apology accepted. It doesn't happen every day that the apology comes from that side of the table. But we take it. Thank you.
Thank you.
Thank you, Chair. Can I proceed?
Yes, please, Colonel.
Thank you, Chair. I think after yesterday's proceeding, Chair, and as the investigating officer in the matter of let us call it the Mukwele docket that is before court, the A1 statement forms part of the docket which is before court. But I tend not to turn on and look at the media and everything that's going in my preparation. But the A1 statement is all over social media and on that aspect. One thing about the affidavit, it contains the name of the complainants, and I have my concerns that that particular A1 statement is an exhibit, and it's a statement that's going to be presented in court. And I'm a bit concerned, and that's why I want to bring it to Chair's attention that I'm not too sure whether there are further documents in this case file that is also going to be flighted out there in the public domain when the case currently is before court. That's just my concern this year. And therefore, yesterday, I said I'm here to assist the Commission, to seek the truth, but at the same time, I have to be cautious that the matter is before a presiding officer in court, and these witnesses and myself will have to testify. These are my concerns. Thank you, Chair.
Thank you, Colonel.
Thank you, Chair.
Yes,
I hear the witnesses' concerns. My concern is I'm not clarified as to exactly what the witness is raising because IDEX counsel is present. And what I think I deduce from what he says is that we should not dig into this particular docket because it's before court. We are back to that sub judice issue. This particular docket is not the one that I indicated we had agreed will be treated with caution because that particular docket is still under investigation.
Which is docket number 3, as I understood yesterday.
Yes. And
there's 1, 2, no problem, and then number 3.
In fact, it's now number 4.
Oh.
It's number 4. There are 4 of them. 1 and 2 are unrelated dockets. This particular one we are dealing with, and docket 4, concern about the same facts or arise from the same facts. And I think it's common cause that they concern General Kumalo. So docket 4, the witness touched on it very briefly yesterday, and that is the docket that carries this particular caution that because that one is still under investigation, we should tread carefully. This current docket is the one, the charges for which General Kumalo and other members of the panel were arrested, have appeared in court, are on bail, and we confirmed that there are no further investigations in that matter. The docket in its entirety has been fully disclosed to the accused to prepare for the criminal trial. It was on that basis that it was decided that they will not pursue the confidentiality rights insofar as this particular docket is concerned. So if that is where we landed yesterday, that we will not apply confidentiality to this. How I understand the witness is raising a sub judice point, precisely the point that IDEC yesterday said it was no longer pursuing. That's why I say how to deal with it, perhaps I would require to get a better understanding, because now I'm in a space where the witness is reviving an application that has been disposed of on the basis, as we mentioned to the chair yesterday, and he placed on record. So is he reasserting the sub judice rule to this docket? If not, is he invoking the right to confidentiality to this particular docket, in which event then we would have to have a full-blown argument as to why confidentiality attaches to this document. But at the same time, it is unfair for me to have that debate with a witness, because it's a legal debate in circumstances where it's represented. So maybe Mr. Botlani would like to come in and explain where we land. Do we reopen that application for argument, or what do we do? Thank you.
Chair.
Thank you, Ms. Zillo. Colonel, I was going to invite Mr. Botlani to be the person who addresses us on this issue. I do not know whether before raising the issue you had alerted him to the fact that you were going to be raising the issue. I do not know. Perhaps let me hear from Mr. Botlani.
Thank you, Chair.
Yes.
I don't understand the concern raised by the witness to be an invitation to the opening of a debate that we've had with our colleague and have closed it in the manner that we have. Indeed, I gave counsel before these proceedings resumed this afternoon. The concern, as I understand it, is the documents being made public. I think it's the flighting of the documents, not that questions on the document cannot be asked. That's not what was referred to me by the witness. So him being asked questions on the documents, it's something that he accepts has got to happen, because otherwise would be hindering this commission from doing the very duties that it has to discharge. But his concern was, as indicated to me, the documents now being available out there in circumstances where some people are still going to deal with them in court. That's what was relayed to me. Not that our colleagues should not ask him questions about the documents.
All right. If some of the question, because I heard the Colonel even refer to names of people, that is, names that may be appearing on the documents. How should the documents be treated? Should there be a need to refer to the names in a context where it's quite clear that that's based on the content of the documents? How are we supposed to deal with it?
It's a difficulty. I've tried to consider it with my colleague, Mr. Ramatsek Sanemi, but we couldn't come up with a mechanism. Because indeed, one cannot say this is a linear process where one can put a blanket statement and say there shall not be reference to names. There are going to be circumstances where the context suggests that reference must be made to a particular name. For instance, if one speaks about the A1 statement, for instance, somebody deposed to it. It's there. And one is not going to be able to speak about the A1 document without speaking about the person who deposed to it.
And sometimes even the point being made may only make sense if specific reference is made to the person.
Indeed.
Yeah.
The A1 statement being, for instance, a case in point. I'm in the hands of the commissioners, really. There is no mechanism that we could come up with as to how do you deal with circumstances such as this, especially, for instance, the docket that we're dealing with. We know that it has been discovered. It is out there. The accused have had access to it.
If I may ask, what is this the same one? Is this the same one we dealt with yesterday?
Confirm, Chair, it is.
Oh. Yeah. What Mr. Law has done is to refer to page 61 thus far. Or 681, I'm sorry.
681, correct.
Yes.
Yes.
And we've been dealing with this document backwards and forwards. So I don't quite understand how the issue arises all of a sudden today. That is the kernel's concern. I know it's not your concern, the kernel's concern. We dealt with this document backwards and forwards yesterday, and we referred to, there was it in this one? Yes, there is reference to names here, but of course, in paragraph 3, that's reference to the people that were being investigated. But with regard to just this one document, I do not quite get it what the issue would be or what the concern would be.
I follow you, Chair, because insofar as the document that appears at page 681, to the extent that we went in and out of it yesterday and mentioned names, there's no undoing that.
Yes.
There's no taking back, for instance, reference to a Mr. Adams, because it was done.
Yes.
So I do understand what you're putting to me, that how does it arise, because this is not a new document.
Yes.
I again understood that concern, perhaps, even though I'm not able to proffer to you a solution to the concern, to be referring to not necessarily this document, but further documents. But your concern is to where context dictates that reference must be made to a particular name, how does the Commission deal with it? I'm not able to provide assistance, unfortunately, to you. But insofar as the document before you now, if for the lack of a better word, damage has been done, there's no undoing it now.
Thank you, Mr. Boljani. I don't know if you want to respond, but
Yes,
my inclination is to rule that we continue as we did yesterday. We are not talking about any other document. It's a document that we engaged with at length, you, my co-commissioners, and me. We dealt with the document at length, so I just do not follow what the concern should suddenly be.
I would agree, Chair, on the basis that the Chair posits that the horse technically has bolted on this particular document. But I have a bigger concern. There are a lot of documents in that particular docket I want to deal with, and that is the question that I need addressed. Is the sub judice rule going to apply to them? Is confidentiality being asserted over those documents? And if so, I need to know how they are intended to be treated.
Perhaps let me ask this question of Mr. Boljani. Mr. Boljani, it is so, as Ms. Silo says, that this particular docket does not fall, or is not the one about which we were told yesterday there must be caution in dealing with it. This document falls under the first category, which is those dockets will be dealt with as the evidence leader pleases, as it were. I'm putting it very loosely. No issue, no concern about that category of dockets.
And I stand by the representations that were made here on day one as to
so no issue about this specific docket. It falls under the category in respect of which you said no issue there.
Maybe I should start here. The difficulty we have is we represent an institution that has lawyers in it, and there's obviously going to be varying views here and there regardless of the counsel that one gives. But insofar as what we presented here on day one as to the treatment of the documents, we stand by that. The documents, in our view, that are affected by the sub judice rule are as identified by the evidence leader. That remains the position. Right. We stand by that.
But you agree that this one is because there was a separation of the documents. There was one document in respect of which we were told caution must be exercised.
Indeed.
Docket, I think I said documents, docket. And that was just one. And the rest, there was no issue there. I called upon you to confirm, and you did.
Indeed.
So
And I stand by that confirmation.
yeah, that's how we should deal with it. If this falls under the category in respect of which there is no issue, let's deal with it on that basis. And it should not matter whether IDEC has lawyers, as Mr. Bodlani said. That shouldn't matter. Thing is, when Mr. Bodlani came, we assumed that he had instructions. And based on those instructions, he adopted the position that he did on the first day of the hearing. And we should proceed.
On that basis, Chair.
Yes, along those lines.
For avoidance of doubt, Chair, and just to be clear, we are proceeding with the docket on the basis as we concluded yesterday morning.
Yes.
So no confidentiality attaches. There are no restrictions to what I can extract publicly from that docket. That is very key.
Yes, yes.
Because our hearings are public. If anything that is ventilated in this room must be done so publicly. That includes flighting the documents. That's part of the public hearings. Unless confidentiality is asserted in terms of Rule 10.4. So we can't be between seats. And as I understand Mr. Bodlani, I think I agree with him that we had a decision yesterday. There are no restrictions absolutely on this docket, except the usual Poppy Act. Yes. Otherwise, we deal with it as it's necessary. That's how I structured how I'm dealing with the testimony of this witness. The witness seems to want to backpedal that and assert some level of confidentiality without necessarily invoking Rule 10.4 in its entirety. So if that's where we land, and IDEC's counsel and I are clarified as to the position regarding this particular docket, then perhaps I'll call upon the chair to explain to the witness.
I think based on what Mr. Bodlani said, the issue is resolved. I will just say, purely as a matter of courtesy to the kernel, you have legal representation. If you have issues or concerns, you should raise them with your legal representatives before we come in, so that submissions are made by your legal representatives. We cannot have a situation where you address us on legal issues when your legal representatives are here. So from where I'm sitting, the issue is resolved, and this is not anything new. It's on the basis of what was agreed yesterday. And I would assume that you were part of the agreement, or you or IDEC gave instructions in that regard. So from where I'm sitting, the ruling is that we proceed.
Chair, may I respond?
All right, let me...
Thank you, Chair. Let me set the record straight first, Chair.
Yes.
We are here for a purpose, and that is to assist the Commission.
Yes.
And to get down to the truth of what is there.
Yes.
My concerns have been relayed to Council. They are aware. My concerns was also, during the consultation process, given to the evidence leader. And that was that the matter, the docket, is currently before court. So, but what I want to say, I do not want to come across like we want to hide anything. So when we started the process yesterday, there was no problem. And I said, Chair, if you will remember, I will be guided by you, because as the Chair, you would know where, where the docket, entry into the docket has been, we will probably have prejudice in it. My concern is that the A1 statement was flagged and it was posted all over social media. So we've dealt with the A1 yesterday and the questions that were asked there, which I responded to uncomfortably. But the main thing is, what other documents are going to be flagged?
How these documents get onto that platform has everything to do with the fact that they are being flighted. And they are being flighted because no confidentiality attaches to them. That was our understanding. That was what was said at the beginning of the proceedings yesterday. And they were dealt with fully in open session yesterday. So I would not understand why there should suddenly be an issue just because they happen to be out there on that platform, that is social media. We have no control over that. Once they are public, they are flighted here, people can grab them and do with them whatever they will.
Yes,
So
Chair.
it's you either claim confidentiality and say the documents should not be flighted, which has not been done here. There's been agreement that they can be, or rather, they can be flighted publicly. They can be dealt with publicly. So, or you could have said, no, they should not be. I'm claiming confidentiality for ABCD reasons, and then the commission would decide whether or not it agrees with what you say. That is not what happened. So I cannot understand why at this late hour you should be raising the issue that you are raising, just because you happen to see the documents on social media. It cannot be.
I understand, Chair.
Yes.
But what I'm saying is that...
Can we please move on? You have your, if you want us to adjourn, and I can give you 5 minutes for you to adjourn, we cannot be addressed by your legal representatives and by you on a legal question. We should have been resolved between you and your legal representatives.
May I request that
You give instructions. You give instructions to your legal representatives. We can't have you. Mr. Bojani has said there's no issue with this. You are suggesting that there is an issue. What do we do? Do we reach a decision between contradictory positions placed before us by you on the one hand and by your legal representatives on the other hand? That's the most awkward situation I've ever seen. If you want us, we can go out for 5 minutes and come back once we've been told to come back.
Could I request that adjournment for 5 minutes, please?
Yes. We'll come back when we are told to. Let's adjourn.
Thank you, Chair.
12. All right, we are ready to resume. Please, you know what to do with your devices. Thank you.
Mr. Bodlani.
Chair, thank you very much for the indulgence. It's much appreciated. And we went beyond the 5 minutes that we had requested. An apology this time has to come from this side of the table. We apologize for that. We have had time with Mr. Pateachi and explained how the process works. In fact, it was not the first time that we did so. He understands why we are currently where we are. There's no dispute about the fact that the docketing issue is with the accused. Nobody knows what he's doing with it. Nobody knows to whom has he revealed whatever content is there. And we've tried to explain those concepts to him and how they impact this process and why it is not available to claim confidentiality, subject to care, and so on. He's ready to testify, and he's going to answer questions that are put to him on the docket. Thank you, Chair.
Thank you, Mr. Bodlani.
And I too must extend my gratitude to my colleague, Mr. Bodlani. I'm happy that we could at least find common ground on this issue. It will facilitate our going forward. It's a pity that we've lost the time we've had, but I believe that going forward it will be a smoother run now that these issues are clarified. Thank you, Chair. Mr. Pateachi, and I must thank you as well for engaging with your legal representatives and for facilitating that we reach the point that we have. Thank you.
Thank you, Council. As I indicated, we want to work together and to cooperate, but I cannot keep something inside when it comes to the witnesses. I had to lay it down, but I understand now, Chair, and we can carry on.
Thank you.
Thank you so much. I had said we will start at CJC 377, which will be in your file 3, starting at page 681. That, as I had indicated, is the A1 statement in this matter that we engaged with yesterday. File 3. You found it, thank you. And I think it is necessary that perhaps I give you a sense of where our engagement today until it ends, where I'm trying to get to so that the commissioners can have the right understanding and to draw conclusions that they will in time do so on the basis of fact. So I bring us to this document because for purposes of your investigation, this is the start point. Do you confirm that?
Yes, Chair.
Thank you. So we will be looking at where you started up to where you ended with General Kumalo, General Lushaba, and Madondo being criminally charged. So those are the two endpoints. Then we will work through the steps until we get to the end. That is the ultimate purpose of the next exercise, okay? So then if we, on this document, on CJC 373, if you could turn to page 683, you are now 681, just go to 683. And we looked at this document yesterday, and we agreed that the issues raised in the A1 are in truth at paragraph 2 and paragraph 3. Because paragraph 1 introduces who the deponent is, And paragraph 4 contains the views expressed by the deponent insofar as the contents of 2 and 3 are concerned. And the last one just simply confirms that he does not have an objection to taking the oath. So the meat of this document is 2 and 3. My reading, and I want to test with you, is paragraph 2 as couched, which speaks of involvement of these high-ranking police officials in the manipulation of promotional and security vetting processes to unduly benefit a civilian person. My reading of that is that it speaks to potential criminal activity. Would you agree with me? Or?
That's correct.
Then I go to paragraph 3. Paragraph 3 speaks to highly skilled and qualified senior police officers who applied for the post being overlooked by the CI management who favored Mrs. Mukwele over them.
Correct.
Now, I analyze that to be definitely not criminal, based on the facts stated there. It sounds more like a HR complaint. Would you agree with me, or do you consider those allegations to point to criminal conduct?
Yes.
Please.
Oh, I wanted you to please start because you spoke over each other.
Okay, we are now in paragraph 3. So we have agreed as to the allegations in 2, what they potentially point to. So
Yes.
I say, from what's in 2, that points to potential criminal conduct.
That's correct, Chair.
Okay, then I turn my attention to paragraph 3, and I say, the deponent states that he was informed that there were several highly skilled and qualified senior police officers who applied for the post but were overlooked by the management who favored Mrs. Mukwele over them. Full stop. Now, I say my interpretation of that is this particular paragraph speaks more to HR issues regarding promotions and appointments and does not suggest any criminal conduct as worded. And I'm checking whether that's your understanding, or do you see criminal conduct in paragraph 3?
When you look at paragraph 3 in isolation, it talks about, it's like an HR, somebody that didn't get promoted or was overlooked for promotion. Paragraph 3 only.
Yes.
But when you take paragraph 2 and paragraph 3 and you put it together, it flows from paragraph 2, that something took place, and as a result, people that were more qualified didn't get that particular post. But when you look at paragraph 2 is telling you that there is possible criminality here.
Yes.
Paragraph 3 is just something that flows out. It is not so much of a focus because it's other people that didn't get promoted. This is not about other people that didn't get promoted. This is more about criminal conduct in paragraph 2. Possible criminal conduct.
I see where you're going with this, but I would like to draw your attention to the wording. It's paragraph 3 speaks to people being overlooked.
That's correct.
So you understand paragraph 3 to mean that what's contained in paragraph 3 is a consequence of paragraph 2, and that can be because they were overlooked. It's not like they did not get the position as a result of the manipulation of promotional and security vetting. Is that how you say it's a consequence?
Chair, when I look at it, okay, there's an appointment, and this appointment here stands out that there's possible criminal conduct here on what I'm getting out of here. But with the appointment, all these, the appointment, the other people that applied, what the whole thing was about is an allegation of a person here being criminality in the appointment of an applicant. So that's why I wouldn't separate the two as 3 from 2. I'll take them all for purposes of the allegation, so that when I look at this and I start to prepare myself, I'm requesting documentation. The documentation that I will request is all the documentation in respect of the post, together with all the applicants who applied for the post. So that's why I take 3 with 2, because when I do my investigation process, I'm going to request documentation for the appointment.
Then, on your understanding, we read 2 with 3 to conclude that there was criminal conduct that resulted in what at first blush might seem to be a purely HR issue. Would
Yes.
that be a fair summary?
Yes.
But the criminal element is there and the sting is in paragraph 2.
Yes.
Okay.
Chair, just to make sure, if you look at paragraph 3 on its own isolated, it's HR. But when you put it together with your paragraph 2, it flows from your paragraph 2, because it's not one person. It's other people that applied for the post too as well, that you are bringing together now when you conduct your investigation. It means that I'm not going to ask for the appointment particulars of the applicant. I'm going to ask for the whole process, if I'm coming across more clear. When you look at paragraph 3, just alone, if there was no paragraph 2,
Yes.
it's HR.
Can we, Pat, then land here? It would appear at first reading to be an HR issue with some elements of criminal conduct. Would that be fair? Or is it both together, it's criminal? And I have no particular preference, I just want to have your understanding.
For me, paragraph 2 is an allegation of criminality.
Yes. Okay. Then we start with this crime that you say is in paragraph 2. We know where we land, because we land in you're submitting an affidavit in support of an application for a warrant of arrest. Now that, Commissioner Baloy, is in file 6. That's the affidavit that I couldn't find in the hard copy files, but only on my electronic version. It's file 6, please. At page 2373. Yes, Commissioner.
I'm going to say before you start with this document, let me just ask something about
Yes.
the paragraph 2.
Two, 373.
Colonel Padiachi, I'm here.
Sorry, Commissioner.
Yes, before you get to this 2373, let me just clarify something about what you were discussing now with Ms. Sillo.
Sure.
In that paragraph 2 of the A1 statement, what do you say, and I need you to say this and that and that, what do you say is the offense, constitutes a crime in that paragraph 2?
Commissioners, Chair, Commissioners, these unlawful appointments, it's not something uncommon. But what people don't understand, that when you appoint somebody and you give them a gratification, the giving of that appointment or employment and the receiving of that employment amounts to corruption in terms of the Corrupt Activities Act.
Okay, you're moving too fast. You're wanting to enter a discussion that is still going to happen.
Yes, yes.
We will still get to that topic. I'm looking at paragraph 2, and this is the paragraph in the document that gets you started, right? That's what you've received. So you proceed with your investigation based on what you receive in this paragraph. And I'm asking for you to now engage in an investigation looking at this paragraph 2, and I'm going to point out certain things and see whether is that what you consider to be a crime. So the deponent, Mr. Adams, says that the allegations relate to certain high-ranking police officials being involved in manipulating promotional and security vetting process to unduly benefit a person, a civilian. So I'm trying to find out from you, did you consider the crime to be the undue benefit, 1? 2, it's a crime because they are benefiting a civilian. It's a crime because she had no prior policing experience. Is the crime that she had no management experience? I'm trying to bear it down so that I understand what, in fact, did you consider to be the crime that then results in you applying for the warrant that you're going to be discussing?
Commissioner, when you look at it, you don't just look at it because she's a civilian or anything. I look at it that in the circumstances of what is here, the allegation that a person has been appointed or given an employment with, put a better word, has been appointed irregularly, although the irregularity comes up like HR type of a thing. So you're looking at the appointment of a person from BMW, first of all.
Is that part of the problem? That's hence my question. Is part of the problem that, and you can list the others, I just want to make sure that we're on the same page. Part of the problem that constitutes this offense with other facts is they're appointing someone from an external company.
Yes.
We don't need to mention the name.
Yes. Yes. I think the first thing is that let's start with the starting point. This is crime intelligence. This is a specialized component. It is a component that I have experience in and where I worked. And it is crime intelligence, and appointing a civilian or a person from the outside crime intelligence into let's leave civilian, pointing a person outside crime intelligence into a highly specialized environment. So these are the small flags that, that comes to my notice. So that's the first one that I can explain to you. And when you look at crime...
But you're not saying that is a crime. Are you saying the fact, because remember, I'm still trying to understand what is the crime that gets you started, or the allegation of a crime that gets you started to conduct an investigation. Are you, from what you've said now, are you saying it's a crime that it's an indication of a crime that they have appointed someone from outside?
No.
Okay.
We're just talking about the appointment as a whole, whether it's from outside, whether it's from inside, the unlawful appointment of a person.
Okay, at this point,
that's the point, the unlawful appointment.
Okay, so our language is very important. The appointment is not yet set aside as matters stand, right? It's not been declared unlawful yet, the appointment.
When it's an allegation initially that needs to be investigated to determine whether it is indeed unlawful, or is it just from the flow of paragraph 3, somebody here that is reporting something because they are unhappy they were not promoted. So it's an allegation first that needs investigation.
But that in itself is not an offense, that they've appointed someone from outside. In itself, it's not an offense.
No, that wouldn't be an offense, just appointing somebody. It needs your investigation, it's an allegation until you can see. So when I look at the paragraph 2, it's an appointment and it's an allegation which draws my attention to investigate.
Okay. So that's it. That's all that made you think, there's an offense here, possibly an offense.
Yes.
It's that it was an appointment of someone from outside.
It's not, like, as I said, Commissioner, it's an alleged unlawful appointment. As I say, it doesn't matter whether it's from inside, whether it's from outside. It's an alleged unlawful appointment of a person with no experience.
Okay, thank you.
Just one question. I don't want to go into detail. Do you accept that in this specific case, the advert invited outsiders to apply for the post? So it was not an internal advert limited to people within crime intelligence. So even I could apply for this position.
Chair, Commissioner, at that time, I did not have a copy of the advertisement.
Sitting here now, do you accept that the advert invited outsiders to apply for this position?
That it was advertised externally, I got to know when I received the documents, Chair.
So sitting here now, do you accept
Sitting
that
yes, now, that I confirm that the advert was an external advert.
Sorry. Colonel, you must wait.
Thank you, sir. Sorry.
Don't speak over a commissioner or even Ms. Zillo. We will have serious transcription problems, please.
Understood.
Please repeat it.
Apologies, Chair.
Colonel, it's a simple point. I'm not talking about in 2024, although that's the fact I'm referring to. You are sitting here now giving evidence. Sitting here now, do you accept that the advert that led to the appointment of the brigadier invited outsiders to apply?
That's correct. It's an advert.
Yes. So if an outsider did apply, limiting ourselves to that question only that it was an outsider who was appointed, there's nothing untoward with that, because that was the whole point of the advert, that outsiders are invited to apply for this position.
Yes, Commissioner.
Yes.
Thank you, Commissioners. I had understood, perhaps I'd misunderstood you. I'd thought the sting of paragraph 2 to constitute criminal conduct lies in the act of manipulation. Did you so understand it as well? Or, because that's what I thought you had agreed with me about, but from engagement with the commissioners, it would appear that now, perhaps I didn't understand you correctly. So that then, just so we are clear, what did you say is the criminal act in 2? I thought you and I had agreed that it's a manipulation, but you seem to now hold a different view. Just to clarify, what is the criminal act? Remember, avoid or resist the temptation to go forward and claim information you subsequently acquired. As you read it, the words in front of you, in which word of those many lies the criminal conduct?
Chair, Commissioners, I'm going to respond like this.
Yes.
Is that when you look at the allegation and appointment with no experience, etc., remember that this is an allegation and it's a preliminary investigation where you will, initially when you look at it, unlawful appointment, what comes up with an unlawful appointment? An unlawful appointment could be a gratification. But first we have to determine...
But you don't have that on this affidavit. Remember, we are still here at this affidavit where the allegation is there's been an appointment of an outsider with no police experience, no management experience, at least that you've been told by this affidavit. There's no suggestion. This affidavit doesn't say to you there's gratification. It doesn't. And I would have been surprised if the deponent said that, because then one would have to ask, what more do you know? But as it stands here, it doesn't speak to gratification. And you capture it correctly. You say there's an irregular appointment. That's the allegation. It's an irregular appointment. The irregularity that you are told here is that they manipulated the the processes in order to benefit an outside person, unduly benefit, that's the language used. They appointed someone with no policing experience and no management experience. That's what this affidavit tells you. So when you start talking about matters of gratification, and it doesn't come from this affidavit. That's not what Mr. Adams alleges on this affidavit.
And please bear in mind what I engaged you on more than once yesterday, which was you cannot look at an affidavit that does not satisfy the requirements of Section 27. You cannot look at it, find that it does not satisfy the requirements, but go ahead and investigate in any event. And only after investigating, you then establish that there's gratification here, there's that and that and that. And then, with reverse reasoning, you rely on that. Now, can you please, with that in mind, you remember me engaging you on that several times? I said, that's not where to start. That's not where to start. Now, with that in mind, can you please respond to Commissioner Baloyi's question?
Commissioner Chair, I'm trying to make logic of it. As a layman, please excuse me on that. I'm a policeman, I'm an investigator. An allegation is made. We have the Section 7(1)A. We have, apologies, I have to go there. It is authorized, the investigation, and I cannot speak from management what they utilized to authorize this investigation, but it is down on my level, that has come down on my level with regards to this allegation. So when I look at this affidavit and I read at this allegation, and in terms of my preliminary investigation, there's a serious allegation here that is made where processes, we use the word manipulated or whatever. So I start my investigation from there. I'm not looking for any word of civilian or anything else. I'm talking about basic, as I'm trying to explain myself as a layman, and I cannot take it any further except what I say here. A person was appointed, processes were manipulated, the person had no experience. That is my start to go out there and look at it and confirm it with further investigation. Chair, Commissioner, I can take it no further than what I've said there.
In how you've described it, just how you've captured it now,
Chair.
that seems a typical HR matter that the Public Service Commission would deal with. If you had taken this affidavit to the PSC, and I'm saying just from how you've captured it, that it seems something that falls squarely within the powers of the Public Service Commission. And you took exception yesterday quite strongly to General Mkwanazi saying you lack the experience to investigate matters. Yeah, rightly so, because you've taken us through your qualifications. But as an experienced investigator, even acting on your superior's decision, Ms. Johnson, maybe Perumal, and whoever the committee is, them having made a decision that this is a matter to be investigated, I would expect that you, as an experienced investigator that you are, you would have looked at this affidavit and said, but this is an HR matter where government has an institution that deals with these kind of complaints. There is nothing, at least that when I look at it now, I don't, maybe let me rephrase what I want to say. Looking at this paragraph 2, I don't see how you would have thought this is a criminal offense. When you look at the facts that are alleged in paragraph 2, and yet I can see how you would say, but this is an HR matter, what are we doing with it? Because remember, at this point, you don't know anything else. At this point, when you get this affidavit, you don't know what you later find out. You say you found out. But of this affidavit, it's difficult to see how you as an investigator would have said, yes, this information speaks to a potential crime being committed that warrants me to investigate further. That's a difficulty I have.
Thank you, Chair, Commissioner. This is just one allegation on appointment that came through amongst others. So it's just not just one thing. It was a whole lot of allegations on different vetting issues, no security clearance, vetting manipulation. So it's a whole lot of different allegations that's there. So I'm not looking at the one and singling it out as an appointment. I'm looking at it holistically. There are allegations, there's serious allegations here with regards to other matters. That's where I'm taking it from. Not just one single allegation that's come to me about, in just that one, an appointment of a person on an bordering on an HR thing, with all the work that we have. This comes in a package of alleged corruption and crime intelligence. So,
all from Mr. Adams. Remember, we are dealing with the Section 27
yes.
referral, which results in a warrant of you investigating a warrant of arrest, people appearing before court. But the genesis of it is what we are discussing now, that referral. Now, these other things, other allegations that you say they are there about corruption and crime intelligence, and they are not contained, at least that we can agree. They don't come from this affidavit.
The only thing that comes from this affidavit is the appointment.
Yes.
But on other affidavits, it singles out the other offenses.
Okay.
So there's not one Mr. Adams affidavit. There are a few. Like there's not one docket, there are a few dockets.
Okay, thank you.
Thank you, Commissioner. I had suggested we move on, but perhaps not yet. You recall yesterday, you sought to persuade the commissioners that you had never seen the Section 27 affidavit. You saw that, I think recently, I don't remember under what circumstances you say you were able to see it with your own eyes and read it. If I understood your evidence correctly yesterday, you testified that the chief investigator told you, related perhaps what could be the content of the Section 27. This A1 is the first document you see, official document that is signed relating to any of those issues. So when now we are dealing with this particular one, which is very narrow in its terms, you then suggest that we look at it holistically and look at other facts. Facts from where? Please point me to a document that will point out the other facts that prop up this affidavit. Which document should I go to?
Thank you, Chair. Thank you, Commissioner. Council, as I explained yesterday, and I stand by what I said yesterday, I did not see the Section 27. Yes. Chief Perumal assembled us as investigators. We have this investigation in crime intelligence, and these are the allegations. So there was a briefing on those allegations. So that was the briefing from him which started the whole investigation and the guidance from him. And as I indicated yesterday, that I can take that no further than Chief Perumal when he comes to explain what he did on that particular time. So but what I can say is in a briefing, and we've been briefed like that on many occasions, not only with Chief Perumal, but with other investigations that I work to get a briefing, and we start off an investigation and we run with it. But there is a difference. An ordinary detective working on a police station and an ordinary policeman working just your normal duties where you go, you open a docket, you register the case, you go, you arrest the person, you take him to court, etc., etc. Whereas with us, there's this, as I say, the procedure that came through. Until it came to my level in the criminal investigation side under Chief Perumal. And as I said to Commissioner, that this is one affidavit of many. So when it was spoken about, various affidavits were taken for the different allegations. And as I said, there was more than one docket.
Yes.
So that's as far as I can take
Here's
it.
my challenge, and I think you will have to make a decision. Either you read this A1, which is the first statement in your docket. Either you read it in the context of another document, which could, the only one I can think of is the Section 27 affidavit. But as you correctly point out, you testified that you said you've never had sight of it. You only had sight of it recently. I have got no basis to gainsay that. So I accept what you say. You didn't see the Section 27. But I want to know the document that precedes this one, this statement, that you took into consideration to understand that the issues are bigger than just employing that civilian. Which document is that? Sorry, if I may finish, I do apologize. I know I'm aware of the various other statements in the docket, but they all succeed this document. They come after this document. So they are not relevant for purposes of my question. The only other document you'd have taken into consideration is one that either came into existence at the same time as that one or preceded this one that we have. What document is that?
Thank you, Chair, Commissioners. Here's my response, and which I've said before, that there's no other document, and I said the Section 27, I had no insight into it. The briefing from Chief Perumal on the investigations and what has been done there and what we need to do moving forward. These are the allegations. There are dockets that were opened in Cape Town. There were dockets opened here. These dockets are with the inspectorate. Okay. So the first was to retrieve the dockets. And on the basis of what is being said, the investigation starts where we request documents and subpoena documents, and where we identify witnesses, we start from there.
Okay, I'm happy to park it there for now. We will come back to the point you've just made. But you remember, I'd said this is my starting point, and I'm going to tell you what my end point is. And then we go back and we walk the steps to my end point. My end point is your, as I said, the file 6 open before you, page 2373. That is the affidavit you deposed to when you applied for the arrest warrants of these panel members, that panel that was headed by General Khumalo. Now, it runs from page 2373 to page 2401. It's quite an extensive affidavit, and I see it is dated at 2401, 24th of June 2025. Page 2401.
That's correct.
And you confirm that's your signature?
That's my signature.
It's dated 24th of June 2025.
That's correct.
You recall that our A1 statement is dated the 6th of January 2025.
That's correct.
So we've got like a 6-month run to get from start to finish.
That's correct.
Now, looking at this document, you deal extensively with the unlawful appointment. You then, if you turn to page 2380, at paragraph 11, at the bottom of 2380, you state, the attached draft charge sheet outlines the acts committed by each of the 7 suspects in a very comprehensive way, which includes charges of corruption, defeating or obstructing the administration of justice, and perjury. Then you say C 418, same file, and that's the charge sheet. against Kumalo, Lushaba, Madondo, Kalakala, Gabela, Nube, and Mukwele. You confirm that?
Correct.
Am I correct? I told you that.
2418, the charge
doesn't
sheet.
see you nodding.
Yes.
So I need you to verbalize the answer. Okay. So now we know 6 months later, we are now we started with that HR appointment of a civilian, possible manipulation of the processes leading to that appointment, overlooking senior generals. That was our start point. We end here where now we are proffering charges of corruption, defeating or obstructing the administration of justice and perjury. Now, staying on page 2418, which is your charge sheet, if you turn to if I may just find my place. But while I find this place, but in this charge sheet, you rely extensively on PRECA, the Act. And you actually unpack the provisions of PRECA at page 2427. And it states, this is under your...
Sorry, sir.
Yes.
Can you please state what PRECA is for the record?
Prevention and Combating of Corrupt Activities Act, number 12 of 2004, PRECA for short. And you introduce PRECA from page 2426. You quote from the preamble of the Act, and then you quote section 1, and in particular the definition of gratification. And at 2429, you quote the provisions of section 3. At 2430, the provisions of section 4. And at 2432, the provisions of 26 sub 1. So those are the sections that you rely on to culminate in the charge sheet at 2433, which charges against the 7 are more or less similar except for accused number 7, who is the employee, the civilian. But in respect of the others, accused 1 to 6, most of them, if not all, are accused of contravening the provisions of section 3A of PRECA, read with sections 1, 2, 24, 25, 26, sub 1A, Roman 2, and 26, sub 3. So these are very specific sections, and therefore very specific crimes. You may refresh your mind by looking at these documents, but if you could assist us to understand, we moved on the 6th of January from employing a civilian. We have introduced concepts of gratification. We have introduced concepts of corruption and related. And perhaps if you help us understand your affidavit so that we land where you have landed in the charge sheet, starting at page 2433. And as you do so, if there are any documents, remember I said there is the steps between the 6th of January to the 24th of June. If there are any particular documents in the docket that you say point towards gratification, point towards corruption, feel free to point them out, and we will turn to them. But for the moment, what I personally am desperate for is to understand how employing a civilian, that act ends up with including concepts such as gratification as defined in section 1.
Thank you, Chair, Commissioners, Council. Let me start off first with the affidavit itself. The investigators do the investigation, and the investigation is presented to the prosecutors who draft the charges and who to charge and what charges they are. So I'm going to move from there. When we look at the charges that are there, the gratification in terms of Section 1 of gratification, definitions of gratifications in Section 1. And it describes what a gratification is. That is an offer of employment, agreement to an employment. So this deals with the employment of a person which falls under the definition of a gratification in terms of PRECA. So when we...
I apologize, but don't rush through it because I'm very concerned by what you have just said. Gratification can be an offer of employment. Let's go to the definition and perhaps read it correctly, right?
No.
Because what you just said I don't think is legally correct.
Gratification, in the definition
Yes.
of gratification under PRECA, employment, contract of employment falls within the definition of gratification in the Prevention of Corrupt Activities Act.
Refer to your page 2427 and let's read it correctly because you don't want to create the impression that offering somebody, giving somebody an offer of employment constitutes gratification. No, that's not what you intend to say. So, and I know that you want to use that definition for us to understand what gratification includes. And that's why I said, this was what, June 2024, 25. So read and acquaint you and reacquaint yourself. And then let's try again. Yes.
Where are you referring to me?
2427, your page 2427. That's where you give the full definition of gratification.
Thank you.
Yes.
Chair, PRECA in Section 1 defines gratification as including money, whether in cash or otherwise, any donation, gift, loan, fee, reward, valuable security, property or interest in property or any description, whether movable or immovable, or any other similar advantage. The avoidance of a loss, liability, penalty, forfeiture, punishment, or other disadvantage. D, any office, status, honor, employment, contract of employment or service, or any agreement to give employment or render services in any capacity, and a residential or holiday accommodation. Any payment, release, discharge, or liquidation of any loan, obligation, or other liability, whether in whole or in part. Any forbearance to demand any money or money worth or value thing. My emphasis is on gratification in D.
And I think that's our first challenge. We can't read that definition on its own. We go to the definition after we've been to the section.
I'm going to the
because
section.
it's a section that will tell us about gratification, and the definition then, for purposes of the Act, tells us the list of what includes gratification. So gratification is not the act of giving somebody employment. Gratification resides in another section in the Act, and then your definition tells you what falls within the definition of gratification for purposes of what is stated in the Act.
Council, yes, Council. You took me to 2427. Okay. Let me explain it.
Yes.
I just mentioned that employment funds under gratification, the definition of gratification, but let me explain it to you or tell you that the section in the Act where the gratification comes in.
Yes.
It's Section 3A
Indeed.
of PRECA. That is where a person receives a gratification.
Yes.
Section 3A, where a person receives a gratification, and that gratification, as I said, is defined in Section 1 under the definition of gratification, which is employment. Then you deal with Section 3B of PRECA, where a person gives or agrees to give and offer somebody else a gratification. And when you look at the both, together with the definition in gratification, you look at let's talk to the relevant matter. The person that was employed, she received a gratification. When we looked at the remainder of the accused, they gave her a gratification. So that is where Section 3A and 3B of the Prevention of Corrupt Activities came in.
Does your answer perhaps not lie in Section 3? Part of what you have just said, but read with, do you have the PRECA Act with you, before you? You
Yes.
don't? Because I think there are some parts of Section 3 you are skipping. You've quoted it at page 2429.
I'm reading it from your
You have quoted it in your
3429.
affidavit, page 2429.
2429. That's where
Yes.
I'm reading it from.
Yes. But then if you're reading the actual section, you stop too soon, because it must continue after 3A and B. In order to act personally or by influencing another person so to act in a manner continued, sub 1, that amounts to the sub AA, illegal, dishonest, unauthorized, incomplete, or biased, or BB, misuse or selling of information or material acquired in the course of the exercise, carrying out the performance of any powers, duties, or functions arising out of a constitutional, statutory, contractual, or any other legal obligation. Roman 2, that amounts to the abuse of position of authority, BB, a breach of trust, or the violation of a legal duty or a set of rules. Roman 3, designed to achieve an unjustified result. Or Roman 4, that amounts to any other unauthorized or improper inducement to do so. So the offer of employment must fit in with the remainder of Section 3 to constitute, to fall within the definition of gratification. Do you agree with me?
Yes.
Now, that forces us then to look at your docket to see whether any of the listed activities there are to be found in your docket. Is there evidence of anyone acting personally or by influencing another person in a manner that amounts to the illegal, dishonest, unauthorized, biased, act that amounts to the abuse of position, any one of them? Is there such evidence in your docket? Will we find it there?
Yes, Commissioner.
Okay. You don't have to remember off the top of your head. We will look for it overnight. But then if you could just tell us the nature of the documents that provide that evidence in the docket. Sorry, I was going to say, would it be statements, witness statements? Would it be any other document? So I'm more interested in the description of the document, if it's in a witness statement, than for you to say the statement of XYZ.
The panel that gave the gratification
Yes.
to the Mukwele, they gave a gratification to Mukwele. Mukwele received the gratification. The gratification that she received was the employment, which was not due. The investigation and evidence that we looked at the documents, we looked at the application, and where we could clearly see that the applicant should have not been appointed. There was manipulation. When we looked at what did she received the appointment, what was she going to be given in return? In return, the post that she applied for is a very powerful post. So in terms of the act, the giving back or return for the gratification does not have to be immediately. It can be at some other time. And given a situation that she's appointed in a very powerful post, and the chairperson of the panel, who was the commander of that whole section. So, although it was not given immediately, it is said at any given time. So he held a position of power over her.
Colonel, I think
appointment.
you're missing the point. And sorry to interrupt.
No, by all means, Commissioner.
The point here is that accepting for a moment that employment is gratification, you must be giving that in order to influence the other person to do something illegal.
Yes, sir.
Because reading that section, it says, in order to act personally or by influencing any other person, so as to act in a manner that amounts to illegal, dishonest, unauthorized, and all of those things. Now, in this case where your offer of employment and contract of employment says your job is to provide services to the South African government, because we have the contract of employment here commencing 1 November 2024.
Yes,
and
sir.
it says, when you get into this role, you must provide these services to the government. So it's in that context that the question is asked. So it can be that she's going to give something in the future, because her providing a service or a labor to her employer, that's not what the section contemplates and what the definition contemplates. It contemplates that in return she must do something illegal, something improper, something unlawful.
Yes, sir. That's what I'm saying, is that what she was going to do is not going to be done immediately, but what you're supposed to give back was not going to be immediately, but can be given at a later stage because of the position that she was appointed in.
She was going to do something illegal.
Correct.
Some years later.
No, we do not know when that would be. But
Precisely the problem.
Because you don't know, that's precisely the problem.
That's precisely the problem
Yes.
with this. That you have you formulated a charge, you got a warrant of arrest, you got people arrested, you have people appearing in court, and continue to do so on the basis of something that you say, and rightly so, fairly so. You say, well, we don't know, maybe in future she was going to do that. How does that, for a seasoned investigator, how does that sound right? As you say it, we don't know, maybe in future she was going to do that, and you've taken all these drastic steps that have a consequence on people's lives and have had a consequence. And you sit there now, many months later, you say, well, we don't know. Maybe she was going to do it in future. It cannot be right. That's a basis on which you went and instituted this prosecution and got a warrant of arrest. That's precisely the problem with this.
And my concern, Colonel, is that the date of the offense is listed in A1 and the supporting annexure as October 2024. But she signs the contract of employment in December 2024. So 2 months after the date of the offense. And the effective date is 1 November 2024. And if you are saying this offense, which amounts to acceptance of gratification, the material facts relevant to it, happened in October. But some years from now, we don't know when. We think it's in exchange of her doing something illegal. I mean, that's circuitous reasoning, which I just don't get. And let me be clear to you, we don't want to go into the merits of whether people are guilty or innocent. That's for the court. That's for the criminal court. What we are concerned with is, what was IDEC's motive? Was IDEC doing these things because they were influenced by politicians, or there was some ulterior motive, or they were acting contrary to the NPA Act? That's really what we're looking at. It's not our place to say people are guilty or innocent of a crime. That's for the criminal court. So I hope you understand that. But to get to that, my interest in particular, is what did IDEC do from the moment it received the complaint? Did it comply with statute? Did it follow correct procedures? And what was the reason behind how IDEC acted? And all these questions and what we elicit from you, we may have to draw inferences from those at a later stage. But just so you are clear, we're not focused on whether people are guilty or innocent of a crime.
Can I respond?
And I hope that assists you and you are able to calm down, and when you respond to questions, it's with that in mind.
Can I respond,
And
Commissioner?
we've taken advocates the last time, but
No,
I did so because I could see that you were struggling with the second part of that definition of gratification.
Commissioner, noted. What I've explained and what you've explained now, that what you are looking for is that whether IDEC was influenced in any way with regards to this particular matter. And that's where I'm saying that's where the emphasis was. But when we're going in deeper into the matter, and this single matter, we're going right into the merits of the whole matter.
No, Colonel, we're going into how you conducted yourself in the lead up. That's what we're focusing on. So your affidavit, where you were asking for a warrant, that's the lead up.
Yes.
That's not in the criminal court people answering to charges. That's IDEC's conduct in the lead up. How did you deal with documents? For example, I asked you a question. Let me give you an example. I asked you a question earlier about whether the advert was, inviting people from outside to apply. And your answer to me was, you were not aware at the time, you became aware now. Now, I've read your affidavit, the same affidavit we're looking at, from June 2025. And in that affidavit, you say so, in so many words, that this position was advertised externally. So it means in June last year already you knew that to be the position because you put that in your affidavit. Again, that's the lead up. That's not what happens in the criminal court.
Commissioner, if I could just stress the affidavit, part of it, and the advert. I did not say that it is now. I only get to know now. When the documents were subpoenaed and we got the documents, the whole appointment documents, the advert was there. So it was clear when we received those documents in February, March 2024. No, 2025. I just got to get the date right. When we received those documents, then the advert was there. All the applicants' documents were in the bundle. So there we saw it externally. And we also noticed that it was advertised previously too as well. Thank you, Commissioner.
Thank you, Commissioners. You, just staying with the definition, I think you stated that this employee was to act illegally in the future in order for the employment to constitute gratification.
She would have been, as I explained, and I did not want to go too much deep into the merits of that response.
No, it's okay. I'm just testing.
Yes.
Did I understand you correctly? So basically, in so saying, you were indicating that if it is a quid pro quo, her part was not done yet. That part would subsequently come after the employment. That's
Yes,
what you sought to
whatever
communicate.
it would be would come
Yes.
after that process.
All right.
It didn't
Now-
have to be immediate.
And I appreciate that you can't put a timeline to it. You don't know when. What I'm interested, sorry, ask me.
No, carry on. It's fine.
Okay. So, and I say I accept that you can't put a timeline to it as to when it shall be done, when she will so act, correct? I'm happy to accept that.
At this stage, Commissioner, at this stage we could not say.
Indeed.
Yes.
And I accept that.
Yes.
What I'm interested in is the act. What act was she to perform, to your understanding?
When we're dealing with investigation as a whole and we look at what is there, it was the capture of crime intelligence, and we were still busy with the investigations on the other aspects with it.
So I apologize to interject. I want us to take it a step at a time. The act that you suspected she would in time commit is the capture of crime intelligence.
Yes.
What is that?
When you look at the various appointments that were taking place within crime intelligence for a specific purpose and a specific reason, from the flow out of the other investigations, that people were being brought in and appointed for specific reasons to be compliant with those particular reasons would actually be unlawful.
I'm interested in in the act you said is the capture of crime intelligence. So I would like you, if you can, to explain to the commissioners the act of capture. What is that? I'm pleading ignorance here. I'm not sure. If we speak of an act,
yes,
one would say they would in time do X, steal from the one to give to the other. So specifying the particular act you suspect she would perform. Now, in response to my question, you say that act would be capture of crime intelligence is what the capture is directed at. I'm interested, what is the act of capture?
Chair, Commissioners, when we look at the investigation of crime intelligence,
yes,
and when we talk about capture,
yes,
it's when the division your people are placed in specific positions to do certain things. Now, certain things could mean tenders, manipulating of tenders. It could be giving out information on operations that are there. The applicant was the head of a very sensitive post,
okay,
which deals with high-profile operations. When we look at the other appointments in terms of different places where people were appointed as commanders of the Secret Service account, and when we look at some of the other investigations which were properties, people are put strategically in place, and that's why we call it capturing of the unit, where you control every subcomponent and every person that's there that is pliant to do what you want them to do. That is more or less what we say capture.
Can I just, I'm interested in her act, not the act of the collective. Interestingly, you didn't say the act would be to steal, for instance. You say the act would be to capture. Now, at the time you made that determination, what about her employment led you to conclude that the act she would in time perform is that of capture?
When you look at the investigation itself and the charges, we looked at, she applied for the post.
Yes.
Investigation revealed that she lied, misrepresented herself on that. The panel were aware of it. Each of the panel members to themselves were, if we look at our other investigations that are there, why they also would have went with the chairperson of the panel to appoint the specific person, because they also had investigations against them. So to give you an example, when you look at one panel member, and I'm actually branching out into something that I didn't want to, but when you look at the first docket that we were investigating, that is the matter of General Lushaba and the alleged housebreaking, and where a classified laptop together with an iPhone cell phone that was stolen, there was no real investigation done there. However, General Lushaba was supposed to be charged, but he was not. When General Khumalo took over as the acting divisional commissioner a couple months after this incident took place, Khumalo put in documents for the loss of the state property. In the lost property, in those statements, it was said that he was drugged. A board of inquiry should have been instituted and disciplinary steps should have been taken against Lushaba. General Kumalo did not do that. General Lushaba was not charged. Fast forward, investigation takes place. General Lushaba is charged for defeating the ends of justice. A disciplinary takes place and he's found guilty for the negligent loss of property, which is also that loss of property and the disciplinary is also that we are also still looking at, because a formal investigation was taken place directly after he reported that incident. And the general that investigated, who was tasked to investigate it, said he was a victim of being drugged by these ladies of the night. When we looked further into the investigation, which they didn't even look and probe at, we found that he was not drugged. So here you have somebody who's sitting there at Crime Intelligence with General Kumalo there, and General Kumalo is aware of it because he signs off on those documents when it goes to the loss management. But here, come forward after the criminal case is investigated and it is found that, and he was arrested, a disciplinary action is taken, a disciplinary case is open and he's found guilty. So that's just one example. There is more on this which I do not want to expose.
So is the complaint, remember we're talking about these charges here,
Yes,
the institution of these charges relating to the appointment of Ms. Mukwele. And we are still at the point where we are discussing how you moved from Mr. Adams's affidavit to formulating a charge sheet in the manner that you have done. That's the discussion at this point. Are you prosecuting, or the charge sheet, are you charging General Lushaba and General Kumalo for including General Lushaba in the panel? Is that part of the complaint? Is that why you are telling us this story about the loss of his laptop? That because there's that history, the charge relating to this appointment, insofar as it includes him, and General Kumalo is further justified by the fact that he hadn't been disciplined previously, or a discipline happened, you are not happy with it, and the outcome and the conduct of Kumalo, and therefore his inclusion in the panel that appointed Ms. Mukwele was part of state capture. Is that of capture of crime intelligence? Is that the logic you say you have applied?
No, the point I was trying to get across, sorry, Commissioner, are you done?
Yes, you may proceed.
The point I'm trying to get at when it comes to the appointments, and as I explained with regards to how the systematic capture took place, where you have the panel that appointed Mukwele, when we spoke about the gratification and when the gratification is going to be given at a later stage or whenever, when we look at Mukwele, the application that she made, the panel was fully aware the processes were manipulated. When you look at, and that's all in the documents, to appoint her. So she was, the appointment of Mukwele was clearly, one, fraud, and two, there was a gratification.
I just wanted to understand the relevance of General Lushaba's loss of a computer and how that was handled to this case that relates to Ms. Mukwele, and in particular, your having concluded this is part of capture of crime intelligence, the relevance of that. Because you seem to have told us something on the face of it, and having listened to you, there's no clear connection that you are making why that case has anything to do with this case and your gratification suspicion, because we must accept At that time, certainly, of drawing the charge sheet, it was, you just had a suspicion, and I think even now, you say, we don't know what she was going to do in the future. So at the time of drafting the charge sheet, we were dealing with your suspicion, and whoever is behind has given you instructions to investigate this matter. Why is it relevant, the computer story, to this charge?
May I respond, Commissioner?
Yes, you may.
Thank you, Chair. Commissioner, I'm pointing out I pointed out to a panel member that sat on the panel, and when I say about capture, what I'm trying to say here is that you have people or members that are obligated to General Kumalo, who is the chair of the panel. He controls the panel. So
Did he pick the panel?
Excuse me, sir.
Did he pick the panel?
Yes.
He picked the panel.
The panel was, maybe I should have started there.
Yes.
My apologies, Commissioner. The panel was selected by General Kumalo. He selected the panel. The members on the panel, together with General Kumalo, it was very clear that they manipulated the process of appointing. When you look at the documents, the evidence, what we collected, this is what came out there. When we looked at...
And you say part of him selecting the panel, or the fact of him selecting these members as a panel, and they are collectively manipulating the process. You're saying that's all part of in furtherance of gratification to Ms. Mukwele for something that we don't know what she would do in future, but you also say that is part of a scheme, or it's a scheme in fact, to capture crime intelligence. That's what you're saying?
Yes.
Happened here?
With the appointment of, that's the panel that has selected, manipulated the process to appoint Mukwele when she clearly should not have been appointed. That is the panel. So when you look at that, here's another appointee coming in to crime intelligence, and there are a few more appointments that are there too as well, that were appointed for a specific purpose. So when you look at it from a capture point of view, commissioners, you have a person in a position as a commander of that specific subcomponent or section that is now you control because you appointed them.
No, yeah, well, I was going to ask you exactly that last part, that I don't know the processes of the SAPS, so maybe enlighten. Does the panel that interviews make the appointment?
Commissioner?
You want me to repeat my question?
Yes, Commissioner.
The panel that interviews, and in this case, let's be specific to this case, the panel is constituted, you say it was constituted by General Kumalo, you say that, and you say he holds this very powerful position, and having appointed Ms. Mukwele, the General Kumalo would have been able to control her or to influence her.
Yes.
My question is, does the interviewing panel make the appointment of the employee in the SAPS?
Thank you, Chair. Thank you, Commissioner. I think this part of it comes up, well, I recommended, I didn't appoint. When we look...
What is your answer to my question? Let's not do a long explanation. Does the interviewing panel does an interviewing panel in the SAPS, and in particular the interviewing panel that interviewed Ms. Mukwele, did it appoint her? Is it this panel that appointed her?
That's the panel that appointed her.
The panel appointed her?
Yes.
Thank you.
Sorry, Commissioner, I didn't understand the first time.
Okay, thank
It's
you.
that particular panel, chaired by General Kumalo, appointed by General Kumalo, chaired by General Kumalo, that appointed Ms. Mukwele.
Okay, so they didn't make a recommendation to somebody else. And I started off by saying I'm ignorant about the SAPS processes, recruitment processes. So I come from a different field, which is you interview, you recommend, somebody appoints. You are saying, in this case, the very panel that interviewed her made the appointment.
Chair, Commissioner, let me disqualify what I said. It's recommend, but that recommend for me, although it's recommend, it's a given that she's going to be appointed.
Well, my question, let's go back to my question then. Don't tell me it's a given, because that's an opinion. You're expressing an opinion. I'm not interested in your opinion. I'm interested in facts. This panel that interviewed Ms. Mokwele, is your evidence or testimony that that panel appointed her? Because it's a simple matter. There is a letter of appointment somewhere, right? Or there's a minute somewhere. So we can verify that if we need to. But right now, I'm speaking from your knowledge because you're testifying and you took certain steps. So my question is simply this. Are you saying this panel appointed as a matter of fact and as a matter of law, because it has consequences, that she was appointed by the panel?
Can I respond, Commissioner?
That's what you say. Thank you.
Thank you, Chair. Thank you, Commissioner. Let me be clear on it, Chair.
Sorry.
This panel recommended Mokwele to the National Commissioner to be appointed, which eventually led to her appointment indeed. That's my answer.
So, okay, let's reprise your answer. So you say now, she was appointed by the National Commissioner.
Correct.
That's all. See, it was easy. That's all I wanted from you.
Yes.
Thank you.
He's the one that eventually signs off.
He's the one that appoints.
Sorry.
He's the one that appointed her.
Finally, yes, he signs off on the appointment.
Thank you.
Chair.
Just to close out on that, the issue of just, Commissioner Baloyi has just conversed with you. Let's just go back to the panel. You say Kumalo established the panel, appointed.
Correct.
In the course of your investigations and considering applicable prescripts regarding recruitment and promotions, I just want to understand what you were able to establish. That panel that you say Kumalo put together, the composition thereof, is it subject to approval by some higher authority, an authority higher than Kumalo, or a designated authority within SAPS? So the constitution of that panel, as your evidence has shown, is it subject to approval by a different authority within SAPS? Secondly, if the answer is yes, was such authority obtained with the result that the panel was approved or not approved, or the authority was never sought? Where do we land?
General Kumalo selected the panel.
Yes.
The panel selection is sent to the head office.
Okay.
The head office approved the panel that he selected.
Okay. So in so doing, the head office, whatever you mean by head office.
The National Commissioner's Office.
National Commissioner's Office.
Yes.
Okay. You don't have HR or some division that deals with these matters? They all go, everything goes to National Commissioner to approve?
No.
Is that how it works? What did your investigations show?
It goes to the HR department of the National Commissioner's Office. So when I say National Commissioner, it's that specific department that deals with it.
What is the HR office of the National Commissioner's Office?
It's the national office, the national HR office for the whole country.
Oh, so why do you make it the HR office of the National Commissioner's Office?
Because
it resides in the National Commissioner's Office. It doesn't, and you know that for a fact.
There's an HR
It's a division within SAPS, correct?
There's an HR department in every province. You have a provincial commissioner where the provincial HR department is also. So you have the National Commissioner's Office where you have the national HR office that is there.
Okay. So you say the selected panel is selected by Kumalo, was sent for approval to that particular office?
Yes.
And that complied with the prescripts, applicable prescripts.
It complies with it.
Was approval granted to the best of your knowledge?
Approval was granted.
So does your charge sheet reflect that the eventual panel was as approved by that division or body? Does your charge sheet take into consideration that approval, or that approval becomes irrelevant because it was Kumalo who selected the panel and put it up for consideration with the result that it is approved or rejected?
When it was stated that it's actually meant that Kumalo selected the panel
Yes.
himself.
Yes.
And it was sent up to the HR department of head office, which was approved.
Now, whoever was approving, did they have the power to disapprove or reject some members of that panel? Do they have any powers, to your understanding, or is it to rubber stamp and it just goes back and they work?
The document that is said, they will compile a document, General Kumalo in his office.
Yes.
So this is the panels that I've selected. Head office will receive it, they either approve it or turn it down.
Yes.
When they respond, they say, your information note or your correspondence dated so-and-so, the panels are approved.
Okay. Now, the approval, if it were granted, what effect would it have on the validity of the panelists selected by Kumalo? Would it have any impact at all?
Well, if the panel is approved by head office, it's approved. It's an approved panel.
Okay.
So that means the recommendations given by Kumalo is approved by head office.
Okay. Chair, I see it's gone 4, 16:09. I'll be moving on to a different topic, so this might be an opportune moment to stop.
Thank you. Let's adjourn and resume at 9:30 tomorrow morning.
Thank you, Chair.
Thank you.